views today. And I'm like, have you been watching? Seriously? Yeah.
There's been a lot of views.
Have there been? I know.
Yeah.
Bunch, huh?
There's a lot of people I know in Montgomery County watching. Just
Really?
oh yeah. 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 It's lovely. You're famous. You're YouTube famous.
I don't think so. And I don't want to be. Let's see here. All right. So, yes, do y'all need a break before we begin?
Yes.
Yeah, go ahead and take a break before we begin. I'm just going to stay right here. Those of you who are on YouTube, we're going for Absolutely, not a problem. Everybody ready?
All right, so the jury.
Y'all seated? All right. Good morning, ladies and gentlemen of the jury. How are you doing this morning? Good. Okay, so just so you know, court calories do not count. And I hope that you had a good breakfast, found some variety, something that you enjoyed, I hope. So we've reached the point in the trial where I'm going to read to you a jury charge. Don't feel like you have to memorize everything that I'm saying, because I'm going to actually give the original jury charge to one of you who is going to be the presiding juror, and that's you'll vote on back there. Not only that, but I believe that one or more attorneys will probably be talking about the jury charge. So you'll be very familiar with it before you even get back there, and you'll see it's going to boil everything down for you. Okay, it's finally going to be. Have you ever flown in an airplane where you're going through the clouds, you can't see a thing, and all of a sudden you pop out above and it's blue and beautiful? Well, that's about what's to happen here. It's going to happen. You're going to see blue and beautiful in just a little bit. So here's the charge of the court that I'm going to give you. Members, and I'm going to read it to you. So it's going to be a little dry, but this is important that you hear and that I read exactly what's on here. So, members of the jury, this case is submitted to you by asking questions about facts, which you must decide from the evidence that you've heard in this trial. You're the sole judges of the credibility of the witnesses and the weight to be given to their testimony. But in matters of law, you must be governed by the instructions in this charge. In discharging your responsibility on this jury, you'll observe all the instructions which have been previously given to you. Remember my previous instructions. Do not discuss the case with anyone else, either in person or by any other means. Do not do any independent investigation about the case or conduct any research. Do not look up any words in dictionaries or on the internet. Do not post information about the case, and don't share any special knowledge or experiences you might have with the other jurors. Don't use your phone or any electronic device during your deliberations for any reason. It's very important. Any notes that you've taken are for your own personal use. You may take your notes back into the jury room and consult with them during your deliberations, but do not show or read your notes to your fellow jurors during your deliberations. Your notes are not evidence. Each of you should rely on your own independent recollection of the evidence and not be influenced by the fact that another juror has or has not taken any notes. You must leave your notes with the bailiff when you're not deliberating. The bailiff will give your notes to me promptly after collecting them from you, and I'll make sure that your notes are kept in a safe, secure location and not disclosed to anyone. After you complete your deliberations, the bailiff will collect your notes, and when you're released from jury duty, the bailiff will promptly destroy your notes so that nobody can read what you wrote. I shall now give you additional instructions which you should follow and strictly follow during your deliberations. First, do not let bias, prejudice, or sympathy play any part in your deliberations. In arriving at your answers, consider only the evidence introduced here under oath and such exhibits, if any, as have been introduced for your consideration under the rulings of the court. For example, consider what you've seen and heard in this courtroom together with the law given to you by the court. In your deliberations, you will not consider or discuss anything that is not represented by the evidence in this case. Since every answer that is required by the charge is important, no juror should state or consider that any required answer is not important. You must decide who you think, you must not, this is very important, you must not decide who you think should win and then try to answer the questions accordingly. Simply answer the questions and do not discuss or concern yourselves with the effect of your answer. You will not decide the answer to a question by lot or by drawing straws or by any other method of chance. Do not return a quotient verdict. A quotient verdict means that the jurors agree to abide by the result to be reached by adding together each juror's figures and dividing the number of jurors to get an average. Do not do any trading of your answers. That is, one juror should not agree to answer a certain way if others will agree to answer another question another way. You may render your verdict upon the vote of, by the vote of 10 or more members of the jury. You might have to change that. The same 10 people or more must agree to all the required answers made to the entire verdict. You will not therefore enter into an agreement to be bound by a majority or any other vote of less than 10 jurors. If the verdict and all the answers are reached by unanimous verdict, and all of the answers are reached by unanimous verdict, only the presiding juror shall sign the verdict for the entire jury. If the verdict is not unanimous, but the same 10 jurors agree to each and every one of the required answers to the entire verdict, then those same 10 must sign individually. You are instructed not to communicate with others about the case, either personally or through computers, cell phone, text message, instant messaging, blogs. This says Twitter, but we know it's now X. This is old. I need to update it. Facebook, Snapchat. Does anybody still use Snapchat? Personal electronic media devices or other forms of wireless communications or social media. These instructions are given to you because your conduct is subject to review, the same as that of a witness, parties, attorneys, and the judge. If it should be found that you've disregarded any of these instructions, it will be jury misconduct and it may require another trial by another jury, and then all of our time will have been wasted. The presiding juror or any other who observes a violation of the court's instructions shall immediately warn the one who is violating the same and caution the juror not to do it again. You'll answer yes or no to all questions unless you're otherwise instructed. A yes answer must be based on the preponderance of the evidence. The term preponderance of the evidence means the greater weight and degree of credible testimony or evidence introduced before you and admitted in this case. Whenever a question requires other than a yes or no answer, your answer must be based on a preponderance of the evidence. If you do not find that a preponderance of the evidence supports a yes answer, then answer no. A preponderance of the evidence is not measured by the number of witnesses or the number of documents admitted into evidence. For a fact to be proved by a preponderance of the evidence, you must find that the fact is more likely true than not true. A fact may be established by direct evidence or by circumstantial evidence or both. A fact is established by direct evidence when provided by documentary evidence or by a witness who saw the act done or heard the words spoken. A fact is established by circumstantial evidence when it may be fairly and reasonably inferred from the other facts proved. When words are used in this charge in a sense which varies from the meaning commonly understood, you are given the proper legal definition, which you're bound to accept in place of any other meaning. As I've said before, if you do not follow these instructions, you'll be guilty of juror misconduct, and I might have to order a new trial and start the process over again. This would waste your time, the party's money, and would require the taxpayers of Harris County to pay for another trial. If a juror breaks any of these rules, tell the person to stop and report it to me immediately. And here are the questions that you're going to answer. Question number 1. Did George Nick Aldoris Sr. have testamentary capacity to sign the document dated February 9th, 2022? And here's your instruction. A decedent has testamentary capacity if, at the time the decedent signs a will, the decedent has sufficient mental ability to understand that he is making a will and has sufficient mental ability to understand the effect of his act in the making of the will, and has sufficient mental ability to understand the general nature and extent of his property, and has sufficient mental ability to know his next of kin and natural objects of his bounty and their claims on him, and has sufficient memory to collect in his mind the elements of the business to be transacted and to be able to hold these elements long enough to perceive their obvious relation to each other and to form a reasonable judgment as to these elements. And here's some further instructions on this question. The proper inquiry is whether the testator had capacity at the time the will was executed. Evidence of incapacity at other times can be used to establish incapacity at the time the will was executed if it demonstrates that the condition persists and has some probability of being the same condition that was present at the time of the will's making. To have sufficient mental ability to know his next of kin and natural objects of his bounty and their claims on him means the decedent must understand who his closest family members are, recognize his relationship to these people, and understand who would naturally inherit his property. You'll answer yes or no to this question. Question number 2. Does the document dated February 9th, 2022 meet all of the following requirements? 1, the document is in writing, and 2, the document was signed by George Nick Polydoros Sr. in person, and 3, when the document was signed, George Nick Polydoros was 18 years of age or older, or was married, or had been married, or was a member of the United States Armed Forces, an auxiliary of the United States Armed Forces, or the United States Maritime Service, and 4, the document was attested to by 2 or more credible witnesses who were at least 14 years of age and who signed their names to the document in their own handwriting in George Nick Polydoros' presence. And 5, George Nick Polydoros signed the document with the intent to dispose of his property after his death. For this, you'll answer yes or no. The next question is, do you find that a relationship of trust and confidence existed between George Nick Polydoros Sr. and Lisa Polydoros as spouses? And here's the instruction on that. An informal fiduciary duty may arise from a moral, social, domestic, or purely personal relationship of trust and confidence. A familial or close relationship does not by itself establish a fiduciary relationship. To find a confidential or informal fiduciary relationship, the evidence must show that the dealings between the parties continued for such a time that one party was justified in relying on the other to act in his best interest. For this, you'll answer yes or no. The next question is conditional. If you answered yes to the previous question, then you'll answer this question. Otherwise, you will not answer this question. Question 3B is, do you find that the execution of the document dated February 9th, 2022 by George Nick Polydoros Sr. was not the result of undue influence? Instruction here is undue influence means an influence existed and was exerted, and the influence undermined or overpowered the mind of George Nick Polydoros Sr. at the time he signed the document dated February 9th, 2022, and George Nick Polydoros Sr. would not have signed the document dated February 9th, 2022, but for the influence. To this, you'll answer yes or no. Now, if you answered no to the 2 questions before, then you'll answer this question. Otherwise, you will not answer this particular question. Did George Nick Polydoros Sr. sign the document February 9th, 2022 as a result of undue influence? And the instruction here redefines undue influence, again, exactly in the same way. For this, you'll answer yes or no. Question number 5, did George Nick Polydoros Jr. have just cause to bring this lawsuit? And just cause means the actions were based on reasonable grounds that there was a fair and honest cause of action, or honest reason for the actions, rather. And to this, you'll answer yes or no. Question number 6 is conditional. If you answered yes to the previous question, then you'll answer this question. Otherwise, you do not answer this question. Question 6 is, did George Nick Polydoros Jr. maintain the lawsuit in good faith? And good faith means an action that is prompted by honesty of intention or a reasonable belief that the action was probably correct, which you'll answer yes or no to. Question number 7. What sum of money do you find to be necessary expenses and disbursements, including reasonable fees, for George Nick Polydoros Jr. to prosecute this suit to contest the validity of the document dated February 9th, 2022? A reasonable attorney's fees is the reasonable hours worked and to be worked multiplied by a reasonable hourly rate for that work. You may consider the following factors as guides in determining reasonable fee for the value of the attorney's services. 1, the time and labor required, the novelty and difficulty of the question involved, and the skill required to perform the legal services properly. 2, the likelihood, if apparent to the client, that the acceptance of the particular employment will preclude other employment of the lawyer. 3, the fee customarily charged in the locality for similar services. 4, the amount involved and the results obtained. 5, the time limitation imposed by the client or by the circumstances. 6, the nature and length of the professional relationship with the client. 7, the experience, reputation, and ability of the lawyer or lawyers performing the services. And 8, whether the fee is fixed or contingent. In this, you'll answer in dollars and cents for each of the following, and I'll need an answer in each of these, okay? For representation in the trial court, you'll answer in dollars and cents. For representation in the Court of Appeals, you'll answer also in dollars and cents. For representation at the petition for review stage in the Supreme Court of Texas, again, answer in dollars and cents. For representation at the merits briefing stage in the Supreme Court of Texas, you'll answer in dollars and cents. And for representation through oral argument and completion of proceedings in the Supreme Court of Texas, again, you'll answer in dollars and cents. Question number 8. Did Dorothea Polydoros and Christy Stovall have just cause to bring this lawsuit? Again, the definition for just cause means the actions were based on reasonable grounds, that there was a fair and honest cause or reason for the actions. And to this, you'll answer yes or no. If you answered yes to the previous question, you'll answer this question. Otherwise, you will not answer this question. Question 9. Did Dorothea Polydoros and Christy Stovall bring and maintain the lawsuit in good faith? And again, good faith means an action that is prompted by honesty of intention or a reasonable belief that the action was probably correct. You'll answer yes or no to this question. Question number 10 asks, what sum of money do you find to be necessary expenses and disbursements, including reasonable fees, for Dorothea Polydoros and Christy Stovall to prosecute this suit to contest the validity of the document dated February 9th, 2022? Again, the reasonable attorney's fee is the reasonable hours worked and to be worked multiplied by reasonable hourly rate for that work. And I repeat the same 8 factors that you may consider as guides in determining the reasonable fee for the value of the attorney's fees, which I'm not going to repeat here. I just said them, but you'll be able to read them here. And you'll answer in dollars and cents for each of the following. For representation in trial court, answer in dollars and cents. Representation in the Court of Appeals, representation at the petition for review stage in the Supreme Court of Texas, representation at the merits briefing stage in the Supreme Court of Texas, and for representation through oral argument and completion of the proceedings in the Supreme Court. You'll answer each of these in dollars and cents. Question number 11. Did Lisa Polydoros act in good faith and with just cause, whether or not successful, in prosecuting this suit for the purpose of having the document dated February 9th, 2022 admitted to probate? Again, just cause means the actions were based on reasonable grounds and there was a fair and honest cause or reason for the actions. And good faith means an action that is prompted by honesty of intention or reasonable belief that the action was probably correct. Here you'll answer yes or no. If you answered yes to question 11, then you'll answer this next question. Otherwise, you will not. What sum of money do you find to be necessary expenses and disbursements, including reasonable fees, for Lisa Polydoros to prosecute for the purpose of having the document dated February 9th, 2022 admitted to probate? Again, the instruction is a reasonable attorney's fee is the reasonable hours worked and to be worked multiplied by reasonable hourly rate. And I repeat again, the 8 factors that you may use as guides in determining a reasonable fee for the value of the attorney's services. You'll answer in dollars and cents for each of the following. For representation in the trial court, for representation in the Court of Appeals, for representation at the petition for review stage in the Supreme Court of Texas, for representation at the merits briefing stage in the Supreme Court of Texas, and for representation through oral argument and completion of the proceedings in the Supreme Court of Texas. For each of these 5, you'll answer in dollars and cents. That concludes the questions. Now here's some instructions for the presiding juror. When you go into the jury room to answer the questions, the first thing you'll need to do is choose a presiding juror. The presiding juror has these duties. to have the complete charge read aloud if it will be helpful to your deliberations, to preside over your deliberations, meaning manage the discussions and see that you follow these instructions, to give written questions or comments to the bailiff, who will then give them to the judge, write down the answers that you agree on, get the signatures for the verdict certificate, and notify the bailiff that you have reached a verdict. Okay, does everybody understand the duties of the presiding juror? Okay. The instructions for signing the verdict are this. You may answer the questions on a vote of 10 jurors. The same 10 jurors must agree on every answer in the charge. It's very important. This means that you may not have one group of 10 jurors agree on one answer and a different group of 10 jurors agree on another answer. If 10 jurors agree on every answer, those 10 jurors will sign the verdict. If 11 jurors agree on every answer, those 11 jurors will sign the verdict. If all 12 of you agree on every answer, you are unanimous, and only the presiding juror signs the verdict. All jurors should deliberate on every question, and you may end up with 12 of you agreeing on some answers, while only 10 of you agree on some other answers. But when you sign the verdict, only those 10 who agree on every answer will sign the verdict. Do you understand these instructions? Okay, so I'm going to sign this. And there will be a page at the very end that is your verdict signature, your verdict certificate, where you will either have the presiding juror sign if it's unanimous, or if it's not unanimous, either 10 or 11 of you will sign. That's the last page right there. To counsel on page number 2, I interlineated 5 with something that I missed there. I can either print this clean or give it to them like it is.
The court wants to do it, sorry, that's.
We'll find it.
Okay, all right. Okay, so I have, and I'll initial everywhere that I've made these. Would you like to see this before I hand it to the jury?
No, sir.
You're good? Everybody's good? Okay. All right, so you'll hand this to the presiding juror when they go back, okay? So now that the charge of the court has been read to you, we're going to commence the closing arguments. And Mr. Cook?
Well, it's been a while. I haven't been able to talk to you guys. I do want to say, I think we all appreciate that you were attentive, that you fell asleep, at least I didn't see you there fall asleep. But it's important for us that we see all of y'all watching, listening, taking notes. We really appreciate that. I'm going to reintroduce myself. My name is David Cook, and together with Jessica Kasiski, we tried to make some recommendations. Lisa Paul George, of course, is my spouse, of George Paul George, who is really the subject of this case. You're being asked to determine whether George's 2022 will is a valid will, and whether Lisa unduly influenced her husband to sign his will. The evidence is pretty clear. It has shown that George knew what he was doing. He relied upon his attorneys, 2 of them, who he knew for a long time. Dan Pappas and Monty Donaldson. Monty drafted the will after Dan and Monty both spoke with George. It was consistent with his prior planning. The will is consistent with what his desires were in 2022. His will was detailed. He listed all the property. He gave property to his children and others. And then whatever was left over, he gave to his wife. That's typical. That's what husbands do. We are asking you to honor George's last wishes, which included taking care of his wife. What they are asking is for you to set aside George's wishes. They want you to erase 23 years of a relationship, 16 years of a marriage. They want you to dishonor and disrespect the marriage as they did during George's lifetime. I think it was Christie who was on the stand. She said the quiet part out loud. At the very end, when we were talking about the funeral plots, and she said, she's not blood. They have shown for years that they did not respect the marriage, they didn't attend the wedding. And now they're coming in here and trying to bolster and say their dad would have wanted them to have the property. Erase the memory, erase 23 years. Erase 16 years of marriage and set aside his last will. Want to go through some of the facts really quickly. George was single for a long time, right? I mean, he wasn't married, he dated, and then he met Lisa. And Lisa told a story about the first time that they met. Everybody said George is mean. And we've all heard that. George is mean, he's direct. You know, if he tells you something, you better do it. He doesn't want to ask why. Lisa went, met him. He didn't turn out to be such a mean person, at least not the Lisa. They hit it off right away. They had a special relationship. When they got married, I don't think there's anybody who came in and testified that wasn't going to say George was happy when he was with Lisa. He even said in his letter, George said, I'm at peace. They had fun. Lisa made him laugh. They were together a long, long time. It was a committed relationship. In 2015, George went.
Yeah, I got you.
In 2015, George went and talked with his attorneys. Again, Dan Pappas, who he had known for years, 30 years, 30 plus years. They were friends as well. And then also Monty Donaldson, who he'd known for many, many years. And they talked about a will in 2015. And what the evidence shows is Monty talks about the 2015 will, Dan talks about the 2015 will. Monty drafted this will, sent a copy to George. Monty says, oh, I didn't know he signed it. But if you go to the bottom, initialed each page, he signed it, and everybody testified, oh yeah, Mr. Fieldbinder, he worked in the office where George was, Marge was his assistant, and that appeared to be George's signature on both pages, that one and the next. Lisa testified that she saw the original of this will. The original of this will was with George. George knew and saw the original will. He had it in a file. It was marked will. It was in one office, and when they closed it, they brought it back and put it in home at the home. They both saw it. Lisa testified she knows George knew about it, that he knew that he had the 2015 will. And they saw it prior to going to the hospital in 2022. The problem is she can't find the original anymore. That's a problem for us. She has a copy. It's missing 2 pages. The 2 pages are near the end. It's basically boilerplate type of things, but she has a copy. Now, what I can tell you about this 2015 will, what it is and what it's not. What it is it's not yet determined to be a valid will. It's not filed for probate. So that is not, I'm not trying to tell you that this is a valid will. What I'm trying to tell you is that in 2015, the evidence is clear. This is what his intent was. If you go, it's just like his intent was, he identifies all 4 of his kids. He disinherits 2. For whatever reason, I mean, you heard that George Polydorus is the kind of guy that didn't forgive people. We heard that time and time again. He was angry. And we'll talk about why that happened. They didn't show up at his wedding. I'm sure that was. And then in addition, can you come up a little bit? Go the other way. I said, it's a gift part of John. Gift over here of Ambassador. And then the residuary, it's weird, it's like the residue, whatever's left over. Everything else goes to Lisa. And that's what his intent was in 2015. They went, they continued after 2015, had a great relationship. I've heard stories, but she only told you a few about Kevin, the dog. And they would go and take Kevin and take pictures for Easter photos and Christmas, and they would travel, and they had a great life. George got sick in 2015. He got COVID. He went to the hospital. And he was there for 3 months. He was prolonged. And we're going to talk about some of the medical records in a little bit. But what I want to point out is that when he was there, he was really sick, at least for sure. I mean, the whole time, but he was really physically very ill the first month in January. And he started improving in February as time went on. And recall, he discharged, and he went home and lived for another year. Right? But in 2022, George is in the hospital. He's already done this 2015 will, and he wants to make changes. So the evidence, and I'm going to try to walk through some of this because there's so much here, and I want to be really clear about what was said, and I don't mean this. But what happened was in 2022, he's in the hospital, he's concerned, all right? I mean, you're in the hospital, you might die, and when you die, what do? You get your affairs in order. You sign a will. The fact that it was signed in a will, in a hospital, Monty Donaldson said, yes, he does like 2 a year. Testify to that. So it happens because of the risk of loss, the concern of dying. George wanted to update the 2015 will. Not Lisa. George wanted to update it. So he called Monty Donaldson. And again, he's known him for years. They started doing this plan in 2014. He comes in the office, they talk to each other, drinks the coffee, and they had a great relationship. Monty knew who George was. And we talked to him about baseline. You know baseline? Baseline, oh yeah, we knew him before. And we knew him after he got sick. So he had a good indication of who George Paul George was. Monty spoke with George while he was in the hospital. George, and the evidence shows that he directed Lisa to write this stuff out. We'll talk about that in a little bit because it ends up in the 2022 will. Write it out. She writes it out. George signs it. She signs it. She sends it to Dan at George's direction and says, here's the stuff I wrote in the will. Dan forwards it to Monty. Dan and Monty both call George. George while he's in the hospital, and George calls Monty and Damon. And they talk. They talk about what he wants to do. He wants to update the will. These are the changes he wants to make. This is the property he wants to put in there. And he's identifying all of it. They've testified to these facts. Now, what Dan said was, yes, when I was on the phone with him, yes, he sounded rough. He was having a hard time breathing at times. But they were able to communicate, and it was very clear. After Monty and Dan talked with George Paul George, they started drafting the will. George told Monty that he had made arrangements for witnesses to be available. I mean, if you're making arrangements for witnesses to be available, you know you're signing the will. Monty didn't have to do this. This is something that George did. Monty met George at the hospital. George gave Monty directions on where he was. Hey, I'm at this hospital. This is where I am. Come up to this floor. This is how you get to it. George knows exactly where he is. Bring the will. He knows he's signing a will. When Monty walked in, George greeted Monty by name, and he entered George's hospital room. We talked about Daniel Pappas, Pastor Chuck Hawkins. That was a very interesting meeting. Pastor Chuck is somebody that works at the hospital as a chaplain. And I don't know if any of you have cared for anybody or have been in a hospital. Chaplains walk in and they want to talk to you about different things. So Chuck walks in to chat up George. George, being George, has a great conversation with Chuck. They talk about politics, they talk about different things, and then George says, oh, by the way, I got a will, I need a witness, would you be willing to come in and serve as my witness? And Chuck said, sure. So Chuck said, here's my card. Call me when you're ready. Jessica Laster is an administrative person that works at the hospital. Was she a nurse? No. Was that George's favorite nurse? Who knows? Arguably, George is a bit of a flirt. That's my favorite nurse. He calls everybody his favorite nurse who ever walks in. But what does it matter whether she's a nurse? She said, George, I'm sure he thought this is a woman walking in my hospital room. And I'm sick. She's a nurse. Let's talk about at the time, George signed the will. At the time is important, okay? And we talked about, you heard some of the, you got to determine testamentary capacity, it has to be at the time. Let's talk about what happened at the time. And fortunately, there are some really good witnesses who told us exactly what happened. Monty took George's unsigned 2002 will to the hospital. When Monty arrived, he and George discussed the contents. Now, George didn't read it, and Monty didn't read the entire thing to him. But in a will, what he read was the important stuff. Here's who's going to get what. Here's who's going to get the remainder. Monty had that conversation with George, and Monty said that he understood what he was saying to him. When he was having that conversation with him, this is when the witnesses walked in. One, Chuck, that he came in. George was having a conversation back and forth with Monty. It did not appear that George was on any medications that affected his ability to think clearly. George did not appear confused. George spoke clearly. There was no slurred speech. It did not appear that George was laboring and talking to everybody. And then all the witnesses in George's presence signed the will at George's direction. And then George signed the will in their presence. Monty signs and never. Jessica Laster was also there. Now, granted, she was there for a short period of time. But during that period of time, she said, no, he wasn't confused, he didn't hear it. What's really important about Chuck is that as a pastor, he signs documents, he signs legal documents, and he has been schooled on what he needs to do. And he testified and told all y'all, hey, I sat there, I looked at it, if there's an issue, if there's some kind of a red flag, if I saw something, then I would say, you know what, I'm not gonna sign it on that day, I'm not gonna sign it, I'll come back another day. And if he saw a red flag, he'd go and talk with the nurse or the doctor. He didn't see any red flags. One of the arguments they're gonna make is, these people, number one, they're not doctors, they don't have to be doctors. They're witnesses, like you and me, who see what happened. And then they came in here and testified. Sworn testimony. Afterwards, George went home. And to confirm, George knew exactly what he did and signed it, was he called Monty. He said, hey Monty, you got my will. If somebody lacked testamentary capacity to sign a will, how are they going to remember that when they got home, oh, I signed a will. Where's my will? And Monty testified and told him, I have it. That was that. George died almost a year later with Lisa at home. The will was filed, probate, and then there was a conquest. I know that there's big reliance on medical records. They've got all these records back here. I think about 3 or 4 of those boxes are medical records. But they're going to throw those in front of you. And I think that the best thing for you to look at is Dr. Ollie's report. He did a report, and I'm not going to sit here. I'm not going to sit here and throw up a bunch of things on the screen, because if you look at Dr. Ollie's report, he identified the good, the bad, and the ugly. And he put in there if there was dementia protocol. He put in there if there was confusion. Let's get this real quick. So his report, he goes through and he says, George was admitted. So I'm not going to throw I'm not going to throw this up there, but you can look at this and see, oh, here it is right here, G&P. That's the number right there. And you can see he's gone through all of this. He talks about awake, alert, and oriented. And one thing I want to talk to you about that, you saw the Dr. Ali test me, right? And I looked competent. I looked like I knew what I was doing. I said it was Friday, it was Thursday, and I couldn't remember the day. I was oriented ×3, but not 4. That's what that looks like. Somebody forgets what day it is. I don't know if some of you are retired or have parents who are retired. I was going to have lunch or dinner with my parents, and they'd say that they didn't know what day of the week it was. It didn't matter. I mean, if you're in the hospital, you don't know what time or day of the week it is. So anyway, he's going through here and he's talking about everything. He talks about encephalopathy, talks about acute hypoxic respiratory, talks about the pneumonia. I mean, he is referencing everything here. And what the other side is going to tell you is, well, he didn't look at the flow sheets. Okay. He looked at everything else and he's identifying everything that's in the medical records. Like I said, the good, the bad, the ugly. And if you recall what Dr. Ali testified was, he said, yes, there was a period of time at night when he was confused. He was on a delirium protocol, but during the daytimes, that cleared up. Whether or not somebody has testamentary capacity, it matters at the time the will was signed. And I asked Dr. Ali, hey, Dr. Ali, what about if you sign this will on a night when it said he was confused, he had altered state, it was 2 o'clock in the morning. Would that be the right time to sign the will? He said, no, that would be a problem. But on the day that he signed the will, Dr. Ali's opinion was he did not lack testamentary capacity and that he was not unduly influenced to sign the will. Dr. Merkel's report. There's that. Dr. Merkel's report is a two-page report. Dr. Merkel did not take into consideration any positive comments. All he did was focus on the negative. And he didn't even cite any records. So when they show you records, what I want you to look at is look at the timestamp. Look at the timestamp. 4 a.m. 12:01 a.m. George did not sign the will in the middle of the night. He signed it in the middle of the day with several witnesses who watched it and said that he was fine. And then Dr. Merkel, when he testified, I asked him, hey, can you paint a picture? We all heard that. I said, let's get this really quick. Paint a picture of what George Polydorus looked like at the time he signed the will. And the picture he painted was, I wrote it all down. He had a hearing device, had to have had a hearing device, despite the fact that George had hearing aids and they were invisible. He had to have a microphone, otherwise you wouldn't be able to hear him. He could not have sat up in bed. He had to have a two-person assist. Absolutely had to have a two-person assist to help him sit up in bed. And we've all seen the picture. He's sitting up in bed. He's eating breakfast. In any event, let's see. He said he would be highly, his respiratory, there would be racing. He would be confused and struggling to breathe. He said it would be panting and unable to talk. And I said, what would he look like? And he said he had acute hypoxic respiratory failure. He had acute respiratory crisis. He was delirious. He had altered level of consciousness. He would have been unaware of his impairment. He was agitated. He was anxious because he was shaking. He focused on some deterioration index, and he said he would be under stress. He wouldn't be able to sit for a minute or two. He was on Presidex, so he was compliant before and had poor judgment. And then he was discussing hospice. And at the end of all that, I said, well, they really weren't discussing hospice. So they talked about palliative care, but then the notes also indicated he was not a candidate for palliative care. During my cross-examination.
Let me object, Judge. That's not what the note said. It said something different. He's saying something that's not in the record.
You may take that up in closing and perhaps show that.
Thank you.
I don't remember, honestly.
I remember it said not a candidate. You remember when I asked the doctor and I went through what happened and all the testimony, the sworn testimony by credible witnesses, people who don't have a dog in this hunt. And I asked him over and over again. I read him the facts and I would say, does that sound like the George Polydorus that you described to the jury earlier? And this is a summary of one of his. There's not very much. Yes. So he painted a picture that George Polydorus was essentially unable to talk, unable to communicate, was panting. But that is not the picture that anybody saw. Who was there? At all. And he had to admit, no, that does not look like it's the same. All right, what we want to do now is look at testamentary capacity. This is what this question will look like. Question one. The first thing you have to determine is, did you have testamentary capacity to sign the will? I'm sorry. I don't read this. Okay. Did he have testamentary capacity to sign the will? And this is the text. Does he have sufficient mental ability? The decedent has testamentary capacity if at the time the decedent signs the will, he has sufficient mental ability to understand that he is making a will. The facts show that he knew he was making a will. I mean, he talked to Bonnie Donaldson, he talked with Dan Pappas. He said he wanted a will. There's evidence in the medical records that states that, yes, he was anxious. He wanted to do a new will. And so, of course, he knew he was making a will. He testified in front of the other witnesses and having a discussion with George. It wasn't just a or it was conversing. They were talking. So yes, he knew he was making a will. He had made one in 2015. He wanted to update it in 2022. He was in the hospital. Of course, he knew he was making a will. Has sufficient mental ability to understand the effect of his act in making the will. He had been represented by 2 attorneys for years. Oh, is this the? Okay. Yes, so here it is. It's 2-2. He says he informed us that his lawyers are working on his will. These thoughts keep him up at night. So the fact that he knows this, Lisa's not there. The fact that he knows, hey, I'm working on a will, should give you an indication of that both of these are met. He understood he was making a will, and he understood the effect and act of making a will. If I die, this is where my property goes. He's been working on a will in 2015. He's been talking with estate planning attorneys. He knows what a will is. He has sufficient mental ability to understand the general nature and extent of his property. This says in general. Now, if you look at the notes that were dictated, if you look at the will, it's very specific. What they want to tell you is, this is a complex estate. There's no way he would have remembered. There's no way he could have remembered all the property. Because there's so many businesses and there's so many bank accounts. His inventory consists of, it would be 2 pages, if not for the boilerplate parts. 1, 2, 3. That's it. 3 pages. This is the complex estate that they want to tell you about. There weren't 10 businesses, there were 2. Each of those businesses held one piece of real property. George knew about this. He was familiar with all of this. He included notation to almost everything that was in his estate in his will. Of course he knew the extent of his property. Now they're going to say, oh goodness gracious, you know, he referenced an account and he said there's $128,000 in it. We don't know who Dan Pappas was talking to. We don't know what Dan Pappas meant by $128,000 in the account. We don't know the answer to that. But there is no requirement for somebody to do a will and say, here are the accounts and there are these balances. It's the general nature and extent of his property. Next is sufficient mental ability to know his next of kin and natural objects of his bounty and the claims on him. That just made, and then the judge is good enough to give us a definition. Next of kin and natural objects of the bounty claims on him, he's the deceit, must understand his closest family and recognize his relationship with these people and understand who naturally inherits the body. George had 4 children. He took good care of those kids. Even when they were adults, sent them to school, sent them to France, sent them to law school, sent them to masters. He took care of them. It's time to take care of his wife. That's what he wanted to do. He's dying. He identifies all these people. Of course, he left $2,500 to George Jr., who he essentially disinherited. But we all know why that would have been the case. Point is he represents all, he identifies all the everybody, and then he makes gifts for everybody. From 2015 to 2022, there's a big change. We'll talk about that in a minute. Let's talk about Nick. Nick is not here. He apparently was fine up until about 2014. He had OCD, it was the advantage. There must have been some. But in any event, at that point, that's when apparently they sought disability. When they seek disability and when it was awarded to him, he received, that's a big benefit, right? I mean, he gets cash from the government, money in his account. He gets help with food assistance. He gets health care. There's a value to that. And once he was on that, he could no longer have more than $2,000 in an account. So why would George not have given Nick money? Because he didn't want to destroy the benefits. And in the will, when you read the will, he talks about, hey, here are these 2 accounts. And don't commingle the accounts, because it's important. They talk about the Timmons property. The Timmons property was property that Nick lived in for a period of time. George sold it. He was fine. This is what he wanted to do. He sold the property, and testimony from the other side was about $100,000, but he was going to put all of that in one account for Nick. George put half of it in an account. He wasn't in the hospital. It's not like, oh, I didn't know what I totally forgot what I was doing. I was confused. He put half of it in an account for Nick. He didn't want to put the other half in the account. I don't know what he did with it. George did what George wanted to with the other half of the $100,000. If he wanted to put more in there, he would have. But he didn't. He didn't provide for him in the will because he would have destroyed those very valuable benefits. And that takes some thought to remember and make a conscious decision. Oh, this last one is you basically have to be able to think about all these things at the same time. So I'm sitting there, I'm signing a will, I know who my kids are, I know the general nature of extending my properties, I know the effect of making a will, and I understand that I'm making a will. And if I can think of all those things, if my mind is good enough at the time that I sign the will to do that, then I have this new power. I don't think there's any question after George had talked with his attorney separately over the phone, after he had directed them exactly what he wanted in his will and the changes he wanted to make. I don't think anybody would question if he can't sit there and understand, hey, this is what I'm signing. And by the way, when you think about this, think about what it took to get to this point. Okay? He's in the hospital, he's sick. He picks up he says, this is what I want, write these things on that piece of paper, sign it, send it, gets it to Dan. Dan calls him, talks to him about it, gets it to Monty. Monty gets to him and talks about it. Monty does the will. And George is telling him, hey, come up here, bring the will. By the way, I got the witnesses. On the day he signs the will, he arranges for everybody to come in and everybody signs this. And that's the testimony. He arranged everything. George knew exactly what was going on. So of course, he's able to flex and remember, these are my kids, this is my property, I'm making a will, and I know what the effect of the will is. He was on top of it. George knew exactly what he was doing. Oh, I almost forgot. So fortuitous. Coincidentally, after this was signed, Dr. Tar walks into the room. And they even admitted, yes, they had been, Dr. Tar and George had been friends for years. And this is the whole baseline of that. Dr. Tar knew George before. Dr. Tar knew George when he was in the hospital. And Dr. Tar went almost every day to visit his patient, his friend in the hospital. And Dr. Tar stood right up there. He got really angry because I felt like he was being challenged. But Dr. Tar stood up here and said, he was never feeble-minded. Never. This is a doctor now who came in 20, 30 minutes after the will was signed. I mean, if Dr. Merkel didn't think that these individuals who came in and watched didn't have the mental or the medical background to be able to make an assessment, well, there's Dr. Tar telling all of us that he was not feeling, that he communicated with George every day. The next question is the informal, so on this one, the student has capacity, signs the will. Does the student have the answer on this one would be yes. At the time he signed the will, he had no capacity, he was able to, and you guys were able to check off all these boxes. The next question is, and I have to tell you, this is a bit of a head scratcher. You can shift the burden on undue influence if you say, oh, she has a special confidential relationship, informal fiduciary relationship with her husband. And if you look at that and say, you find a relationship of trust and confidence existed between George Paul Sr. and Lisa spouses. The answer to that is yes, of course they did. I mean, if any of us are married or have a partner, I mean, we know that we trust each other. That is not what this question is asking. It's more than that. It's not just that they were husband and wife, that she was there doting on him every day, taking care of him. That's not it. If that were the case, every husband and wife, wife and wife, every single one would owe the other an informal fiduciary duty. That's not it. It has to be more than that. And the question becomes on reliance. Is George relying on her to do certain things? George had two attorneys. He was relying on those two attorneys to help him with legal issues, to help him with the will, help him make sure that the will was correct and everything was signed properly. He relied upon his attorneys. George relied upon the doctors. The doctors worked with George. George talked to the doctors about his care. Lisa was the wife. It was not over and above. She's there being the wife, doing typical wife things. George is relying on other people. He has fiduciary relationships with other people. Lisa's just the wife. Now Lisa puts in a text, she says, hey, me and Mary, and she informs them, hey, me and Mary are gonna be working on, we're gonna be helping, I don't remember the exact words. George and Mary and I are gonna be doing the business stuff for George, something like that. It was in a text. And she says that. And administratively, that's what she was doing. She was helping George. She was writing checks. What's interesting is there's a text from the other side, and they say, but you know, she was just being a secretary. They can't come off of that. I even asked her, hey, you want to change? You want to change what you wrote down there? I was surprised. I thought she was going to change secretary. She didn't come off of that. Yeah, here it is right here. Don't forget, for all intents and purposes, Lisa was Dad's secretary over the last year. Secretary does not owe fiduciary duties to anybody. This is what, and this is over the last year. So this was done sometime after George died. So it was done with the full knowledge that she had told everybody, hey, I'm going to be helping on the business. It can't come off of this now. There's not that special fiduciary relationship. She was not acting under a medical power of attorney. There was not a statutory durable power of attorney. Now, I know what they're going to show you is they're going to show you a record that somewhere in the hospital they said, NPOA, medical power of attorney. Well, date wise, it was after the date of the will. And I don't know that she actually knew whether or not she was acting in medical power of attorney, because she wasn't, because there was not one. She couldn't have been acting, but it was after the date of the will. And I want you to look, when they show records to you, look at the date. Look at the time. Look at the date, look at the time, because it matters, again. Oh, yeah, I mean, at the time, the will is signed, that's what matters. Okay, so the answer here is no. There was not this special relationship that they're trying to foist upon her. She's in the hospital room, she's being a good wife. She's there all the time taking care of him. She is not in some kind of special relationship where he is putting trust in her to do a bunch of different things. She's there clearing for him and acting as secretary, an administrative person. Go to the next one. The next one is undue influence. Depending on how you answer that question, it's going to be, well, it's either going to be a yes or no, but I'm just going to throw this one up here. Depends on how you answer the question. There's going to be some direction. At the end of the day, this is the test for testamentary capacity. And I'm sorry, test for undue influence. So they said that George lacked testamentary capacity to sign the will. But if he had testamentary capacity, well then he was unduly influenced to sign the will. You find execution of the document dated February 9th, 2022 by George and by George Wilson was not the result of undue influence. The other one's going to say was the result of undue influence. It just depends on how you answer that other question. Undue influence, and if influence existed, it was exerted. The influence undermined or overpowered the mind of George Polydorus. I mean, we all know who George is. At the time he signed the document, George would not have signed the document, but for the influence. And what's important here, I mean, this is another head scratcher. How did Lisa benefit from these changes that were made from 2015 to 2022? Think about it. Here, this will, which again, we can only find a copy of right now, 0 to Georgie, 0 to Christy. Dorothea got the same part of condo, but it wasn't there anymore. And then Nick got the ambassador. And again, look, this is 2015. This is probably before the period of time when he was actually got his disability. And of course, you can see that changes. But the point is, 2015, nothing, ambassador. And this is the problem, right? You know, so George wanted to do a new will. Lisa didn't want to do a new will. Think about it. Here, she gets the residue, whatever's left over. Everything except for the ambassador condo. That's what she would have gotten had this will been found. And again, we went to the hospital, he saw that they both saw that the will was in their home. She would have got everything. Now in 2022, here are gifts that go to these different people. Why would Lisa agree to any of that stuff? I mean, I get less now. And over here, I almost got everything, and now I get, well, not everything. I don't get this, I don't get the Lexus car, I don't get this, I don't get the cash. I get whatever's left over. How did Lisa unduly influence her husband to sign a will giving property away, and she ends up with less? It does not make sense. And if you're wondering, that doesn't seem like it makes sense, you're right. It doesn't make sense. She wouldn't have done that. George wanted a new will. He disinherited Christy. He wanted to fix that. He wanted to make sure that everybody got something. He wanted to make sure that his grandkids got something. He wanted to make sure to transfer the mental interest to somebody else. He wanted to make sure that Dorothy and Christy got an ambassador and some extra cash. This is George's will. It's not Lisa's will. If it was Lisa's will, it would say everything to Lisa. I get everything. I don't want any of these things here. Every time she wrote what George told her to write on a piece of paper, that was more money away from her. And why did she get it? Because she didn't care. It was George's will. She wanted George to do the will that George wanted to do. It's that simple. How long did you put the no contest clause? Next, the no contest clause. George had a will that included no contest clause. The no contest clause is punitive. It says, if any beneficiary hereunder should contest the probate or validity of this will, exactly what they did, then all benefits provided for the beneficiary are revoked. And what that means is each benefit conferred herein is made on the condition precedent that the beneficiary shall accept and agree to all the provisions of this will. Hey, I agree to everything. I'm going to accept what you give me, George, because you gave it to me, and I'm going to agree to that. And the provisions of this section are essential to every party. But if you don't agree to that, then the no contest clause kicks in, and under the clause, you don't get anything. Now, in Texas law, you can come in and say, I know, I contested it. I know my dad wanted to put that in the will. I know that was supposed to apply to me, but I get to come in if I'm in good faith. You want to put it that charge.
Oh.
If I'm in good faith and I prosecuted the case in good faith and with just cause, then it's my get out of jail free card. And that's what they're going to argue to. But the way this whole thing started, and they tried to deny this yesterday, honestly, the way this whole thing started was after the will was filed for probate, they all got together and they started communicating with each other. Even though they didn't communicate with each other on a regular basis, it was, I guess, important enough to get away with this address. George, on behalf of his sisters, said, I'm going to file a contest. And we're all going to get together. We're going to have a Zoom call. We're going to talk about what this will contest is going to look like. But I'm the one that's going to do it because under the will, he only got $2,500. So what? You can file the contest. He didn't know anything, no personal knowledge. Because remember, and I'll talk more about their testimony later, but remember, George hadn't seen his dad since 2015. He never saw his dad again. Knew his dad was in the hospital, tried to blame it on Lisa being the gatekeeper. Oh, I couldn't go up there because Lisa's the gatekeeper. Come on. He wanted to see his dad. He's going to go see his dad in the hospital. He only saw his dad 5 times between 2007 and 2015. But he's the one that's going to contest the will, even though he has no personal knowledge, doesn't know what's going on. But they're going to hide behind the scenes. If you do it, because I don't want to lose it. Why would you do that? Ask yourself, why would you put somebody else to contest the will? You hide behind that person. Why would you do that? The answer is, if they were worried that they weren't going to get there. They were worried that they were not going to maintain this, which us calls in good faith. And that's exactly what happened. And then what happened was yesterday I said, oh, no, you participated. And what she said was, no, I didn't participate. We wanted to wait 8 months before we collected all the records. Because apparently, I guess, if they hadn't had a record yet, and George father, not a good credit, because he didn't have a record. But we want to wait, we're going to wait 8 months until we go, and then we pursue the will. Not true. We had to have a big debate, and she finally acknowledged, oh yeah, I received that letter. I received that invoice. I received that email. I received that email. And then you know what else I did? I wrote a check for half of this. It actually says, here's the invoice number. Oh, I'm sorry. She said I didn't write the check and pay it to the law firm. Instead, I paid it to my brother. So my brother was the one who paid the entire amount. Keep going. My brother was the one who paid the entire amount. Boom, invoice number right there. But then, here's the invoice number. I paid for half of it. So I didn't have to work. They were participating. They wanted to tell you, no, we weren't participating. We really weren't. They were paying for it, half of the cost. They were hiding behind George. And the way this case has been prosecuted, you saw some of it. It hasn't been pleasant. They have attacked Lisa. They attacked her in here. I mean, there was a lot of this in front of you guys. One time she said, no, I did help George sometimes. I sent emails to Dan Pappas and before he went into the hospital. And they threw the document in front of her and said, here it is. You sent that 2 months ago. They had the other records. We had to come up here and go, oh, look, here are the records that show that she was communicating with Dan Pappas 2 years before, talking about selling her property. They knew it, they had it, they ordered the records, but they didn't want to show it to you. The other thing they did was, oh, look, you started signing checks after George went into the hospital, and for that reason, you have an informal confidential relationship. That's what they're trying to tell you. That's what they're trying to bolster. Those checks were ordered by them. They had those checks. But what they didn't show you was that she had been signing checks 2 years earlier on the account. She's on the account. And we had to come in and show that. They had it, they have those records, but they hid it. The other thing too is the allegations that were made here during the lawsuit have been awful. Awful. And it was just to attack Lisa Polidorus. Lisa slept around before she got married to George. Years ago. No personal knowledge. That's just the allegation. Then Victoria. Who the heck is Victoria? What does that have to do with anything? They talked about Victoria. I would object. Relevance with already in. Okay. What relevance does Victoria have to anything? Nothing. They were just trying to infer that, oh, Lisa came in and she moved in on somebody else's girl, 23, a guy 23 years ago. I don't understand it. It's perplexing. It's just to be mean. Lisa married Dad for their money. Lisa loved George. George loved Lisa. Lisa invited Haley over, knowing that she had COVID, and that killed George. Lisa killed George. These were the sorts of awful allegations that were made throughout all this. Lisa didn't even call 911 when George died. And then, of course, Lisa's not black. These sorts of allegations were made throughout the entire litigation. They talked about, well, unable to grieve. She never got to grieve because of all of this. It was not in good faith. It was not prosecuted in good faith. It was mean. It was mean. We're going to look at attorney's fees just really quickly. Argument. So there's going to be a charge you can ask about attorney's fees. I'm going to argue that 580,000, 500, whatever the amount of attorney's fees they spend on this estate is outrageous in light of the full amount. They're going to say it was worth $4.5 million. It's probably worth more than that. Well, that's not true. There's about $700,000 that wasn't even part of this. There was debt. But you heard them, they wouldn't even acknowledge the debt. Well, if you have a $4.5 million asset and you got $4.5 million in debt, wouldn't that be a zero asset? And the answer was no, I agree with you. Yes, obviously. You have to take that into consideration. The value of this estate is not $4.5 million. The amount of attorney's fees they spent on this was outrageous. It's too much. And the attorney's fees that we spent, again, we've been in this from the beginning, from the get-go. She doesn't want to be here. She had to hire attorneys. Our attorney's fees were $208,000. And then we also asked for $30,000 for court of appeals and $30,000 for the Texas Supreme Court. So the way that it breaks out, the way that it breaks out is going to be 208,000, it'll be 30, and let's say you'll just break that 30 out again. But we're asking for our fees. We took a substantial discount, just recognizing how long this trial was and how much preparation it took. At the end, you're going to be asked a question, and if I have an opportunity, I'll come back and speak to you a little bit more. But at the end, you're going to be asked these questions. And remember when I talked to the board documents guys, I said, you can't A, you can't B. Okay? Same thing. Either you're in camp A, and you believe that those people didn't lie, the witnesses didn't lie, Monty didn't lie, Dr. Attar didn't lie, Dan didn't lie, all that stuff happened. That he wasn't confused at the period of time he signed the will and all the discussions leading up to it. That's camp A. That he wanted to change the will because his 2015 will wasn't what he wanted to do, and he wanted to increase the gifts. Can't be, on the other hand, there's some grand conspiracy. Nobody knows. They should have asked the medical records. There should be something in the medical records that says, oh, we're going to test all this for testamentary capacity. That doesn't happen. But can't be is there's a grand conspiracy. Monty lied. Dan lied. Pastor Chuck Hawkins lied. Jessica Laster lied. Dr. Attar lied. All these people lied. That can't be. You came in here with common sense. Use your common sense. I mean, you do not need to leave that at the door and disregard what happens here and what we know happens. We're asking you to recognize that relationship, to recognize that marriage, and to uphold George's wishes.
Thank you, Mr. Cook. Mr. Christopher?
That's pretty good. I mean, you saw why this is so expensive. I mean, that was quite a tale. And what I'd like to do is tell you, we'll look at the wheat, not the chaff, and look at the signal and not the noise. You notice, I think Mr. Cook used almost an hour to talk very little about the medical records. We didn't want to bore you with that. We didn't want to, bother with that. And the reason is because his whole story is that this will that he's trying to offer constitutes the words of George Polydorus. There's no way that could be the case. Let's go back to the very beginning when Mr. Pappas. We're not saying he's lying. We're not saying any of these witnesses is lying. They're just wrong. They don't know the details. They took a very superficial look at George Polydorus. They didn't know the medical. Dr. Attar, the cardiologist. Yeah, he got mad at me because when I was asking him questions about, well, what's the basis of your opinion? And I asked him questions like, well, who were his doctors? What were his other conditions? What were his meds? He wouldn't answer. He didn't know. He got mad at me. And he says, well, why don't you show me the records? Well, that's his way of saying, I don't know. Why don't you woodshed me as a witness and get me ready? He should have been ready when he got on that stand and said, in my opinion, George Polydorus was fit as a fiddle. He wasn't feeble-minded, but he didn't do that. He didn't know anything. He didn't have a basis for his opinion. Dr. Merkel, on the other hand, said he went through, touched all the records. I'm sure he didn't read all 14,000, but he went through the records in gruesome detail and had lots of information and lots of facts that while we're talking about the doctors, Dr. Ali did not know. Now, Dr. Ali's a lying. I'm not saying he's lying. I'm not saying Attar is lying. Attar came in here to do a favor for a friend and his widow, and he got asked to do something that he wasn't ready to do. And if he'd known the facts, who knows, maybe he would have come in. If he knew all the things that I'm going to get to talk to you about, and Ms. Smith is going to get to talk to you about what the real George Polydorus was like on February the 9th. Now, Mr. Cook, you will recall, you know, and he's got a client he's representing. I mean, let me just say, you may remember he first started out with an exhibit 1B with Mr. Pappas. And again, Mr. Pappas said, yes, I talked to him, fit as a fill. Well, remember Mr. Pappas, when I cross-examined him after he told you the story about, yes, we talked several times. Yes, he was great. This is what he wanted and this is what we put in the will. Well, all right. Did you talk to him anywhere other than the hospital? No. When you talked to him at the hospital, what was he like? It was hard for him because of his lungs. He couldn't breathe. He didn't have the capacity to communicate. So you've got Mr. Pappas saying, this is what he wanted, this is what's in the will. And he also said, we've been talking about this for years. Well, then if you, first of all, he got it wrong. He hadn't really talked to Mr. Polidorus because, as he admitted in his deposition, I guess he forgot this when he was giving opinions to Mr. Cook. He couldn't communicate because of his lungs. He couldn't breathe. He had a hard time breathing. Those were the conversations that he had with him. But when he's in the hospital where it's hard for him to breathe at all, and remember on February the 9th, when he signed that will, he desaturated to 89. Dr. Merkel said if you get below 92, it's kind of iffy. He desaturated to 89. And the other thing, Mr. Cook glossed over this, that he was breathing hard and he started panting. And when you do that, you try to figure out back there, do whatever you want to. You are the Supreme Court of the facts. If I'm telling you something that's not what you remember, you disregard it. If Mr. Cook's telling you something that's not what you remember, you disregard it. You go with what you think the facts are. But you remember on the respiration, Dr. Merkel knew the respiration, knew the DSAT. Nobody else did. And remember, Mr. Cook said, well, Mr. Witness, Mr. Hawkins, and all these witnesses, no sign of medication. Well, he was on drip Presidex. He was on high dose IV prednisone. He was on a delirium protocol. And there's a lot more in there. But these witnesses knew nothing about it. They're bringing you witnesses that don't know what they're talking about. They're not lying. They're just trying to help somebody out, and they're not fully informed. Just like Dr. Ali never looked at any of the records on the 10th, 11th, and 12th. And Mr. Cook talked about palliative care. That was on the 12th. And there's a medical record on the 11th that says the last 48 hours he's been doing bad. By my calculations, that gets you pretty close to the 9th. When he desaturated to 89, his heart rate went up, and nobody saw him. These witnesses never saw the breathing cannula. These witnesses did not see the earpieces. Now, when I first thought about the earpieces, I thought, well, is that a big deal or not? I don't know. But it's a huge deal. You heard, I believe it was, I don't know if it was Dorothea or Christy said you had to walk up to him and speak into the microphone. So if you've got Mr. Polidorus and he doesn't have those good hearing aids on and nobody's talking, and none of the witnesses talk about that. Monty Donaldson, star witness, doesn't even think it was that there was any equipment in the ICU. He's not lying, he just doesn't know what he's talking about. Pastor Hawkins. What did Pastor Hawkins say? Well, you know, I was hoping, first of all, he thought he was in the general part of the hospital. He didn't even realize he was in the ICU. Pastor Hawkins was saying, I was hoping he'd be discharged and I wouldn't have to do this because I don't want to go out on a limb. And what did Dr. Merkel say? Dr. Merkel said he was probably violating protocol because he was doing this will ceremony without any medical input, just like Dr. Attar was testifying without any medical input, just like Dr. Ali was testifying without knowing what happened on the 9th, 10th, and 11th. And Dr. Attar didn't know about all the nurses' notes and the PT notes and the OT notes. And that's where, according to Dr. Merkel, that's where the hard work is done. It's not the doctors splitting in and out. I mean, I've dealt with my parents. You've probably done the same thing, perhaps. The doctors are like ninjas on the ceiling. They come down when you're not there to see your loved one, and then they're gone. And they do a lot of great work, but the nurses, the OT, and the PT people, they're in the trenches. They know what's going on. At least they know. They may not know all the medical stuff, but they know what's going on in terms of behavior and what George Polidorus may have been capable of doing. All right, so this one other thing, see, this is why this is so expensive. George Polidorus did not want to file this lawsuit, did not want to contest this will. But what's he going to do? He finds out that his dad, who was deathly ill, signed a will in the middle of that when he's on death's door. Not only was he on death's door, he didn't really know. Everybody's trying to be positive, and a lot of these, he's doing better. You're always thinking positive. You're not thinking you're going to get that call, 2 days later, that it was too late and that they're gone. So everybody's trying to be positive and looking to be positive at the time. But then George finds out the will's been probated, and by golly, it was signed right in the middle when Dorothea and Christy, who visited him, what did Christy say when she walked in on February 14th? I was shocked. I broke down at the condition he was in. And so they're saying that, well, you've got the words of George Polidorus, it's this will, and that's what he wanted to do. Well, let's go to this Exhibit 1C. Now, Exhibit 1C is this, and you'll have this back there, and you've seen it when I cross-examined Mr. Pappas. The first thing they offered was, I believe it was 1A or 1B, but anyway, it was the communication on February the 1st, 2022. And the first thing they offered into evidence was just the handwritten notes. And Mr. Cook said, these were the directions from George, right? These were the instructions from George, right? Yes, these are the instructions from George. Well, come to find out, he forgot to offer the cover page for that. The cover page says, hey, Dan, attached are things I wrote for the will. This is Lisa emailing from George's computer, by the way. And then come to find out, it's George's instructions, his directions. Everything's in Lisa's handwriting. And by the way, if you want to compare, all right, here's what I think is really interesting. They're trying to say that this will, it's over here, it's a ring-bound will, that this will is George's words. And what I'm here to tell you is, and the evidence will show, and if I'm wrong, you correct me, read my papers. This is Lisa, this is not George. That will is from Lisa, it's not from George. George was in no condition to do this sort of thing and to get into that kind of detail, and that's what the evidence shows. So you haven't heard from George, and you're going to hear from George a little bit later. Okay. And in case I'm talking about the signal, the important things, the nuggets, and here's a nugget. We talk about Monty Donaldson, and this is in evidence, and Monty said when the next witness walked in, do you recall anybody greeting one another? And Monty says she, the nurse or the administrative assistant, she spoke to George and he spoke to her, and he turned to me and said, this is my favorite nurse, so and so. So to put it in context, Monty Donaldson is telling you all that when Ms. Lassiter, she's not lying, she's a straight shooter. She told you exactly what happened, which is a big nothing. She didn't know what was going on with George. But what Monty Donaldson's testimony was, oh yeah, she came in, George recognized her and said, this is my favorite nurse. So either that happened and George didn't know what he was doing, or Monty imagined that it happened, because we all know that Ms. Lassiter was not a nurse and did not know George from Adam. So that's not true. I don't know why. All I know is that part of the story falls apart. That's not true. Okay, Judge, how much time have I used?
About 15 minutes.
15 minutes.
Yes, sir.
And so we have 30 minutes, and Mr. Cook has about an hour.
The timer, Judge, just for the record, he's at 12 minutes.
I stand corrected.
Just make sure we're following it.
Thank you. I was rounding.
I'm sure you may not like to hear that, but anyway. So why did George contest this? Well, he heard that the will had been signed, and again, I don't understand this angle of attack. How dare you meet with your sisters and decide what happened to your dad when he signed this will? How dare you conspiring? How dare George meet with his sisters, the two siblings who saw his dad in the hospital? Of course he's going to do that. He's going to talk to the witnesses to find out, hey, what was going on with dad? And he had been getting reports, didn't have personal knowledge, but he'd been getting reports. And then when this will came out, signed right in the middle of all that, he talks to his sisters who said dad wasn't capable of doing that. Of course he's going to do that. And that's why he filed. I mean, what did Dorothea say? Dorothea said he could barely eat, couldn't brush his teeth, couldn't go to the bathroom. You had to speak to him through the mic. He had terrible breathing problems, which is what Pappas said. He was always wearing his cannula, which is that big device, which, by the way, you can look in the records. He had injuries to his ears or wounds to his ears because of the cannula looping over his ears, which means what? It means it was pretty big, pretty obvious, and he wore it all the time. Why would you take that off for the will signing? Maybe that's part of the reason he sat it to 89. He couldn't write a check, is what Dorothea said. He couldn't write a check. He had no business making any kind of big decision. So what did Christy say? She saw her dad, she broke down. I believe it was February the 14th, 2022, 5 days. I was in shock. I had to get close to him to talk. He couldn't recognize me at first. He had the headphones on, the mic, the cannula. Yeah, he understood her, but only sometimes. And they weren't talking about things related that Lisa had sent to the lawyers on February the 1st. And Mr. Cook said, and it'll be up to you. It'll be up to you. He said, oh, like the judge said, when you're in the plane in the clouds, in February, the clouds parted and the sky got blue. You look at those medical records. I'll talk about it a little bit. That is not the case. You don't get consulted, and it's the doctors who went to, you heard Dr. Merkel testify to this, the doctors went to Lisa and to Mr. Polidorus and said, maybe you should consider palliative care because you're not recovering. You're not, and you heard Dr. Merkel talk about the scarring of the lungs. He talked the bleeding of the lungs, the COVID brain, the COVID pneumonia, the COVID sepsis. You heard all of that. You couldn't talk about any of that. It's just like, hey, what Lisa said was turned into this will. That's his words. End of story. That's what George wanted. And these guys, how dare they challenge that? So then the question is, after that, after she saw that he couldn't understand and got COVID brain, you can't understand, and Dr. Merkel testified and confirmed, consistent with the eyewitnesses, that they couldn't understand, that he could not have understand. Doesn't make sense, and it's not true. It's not true that that will is George Polidorus's. And you know what? He talks about the 2015 will. Now, how does that make sense? The 2015 will, there's no good copy, there's no original. For all we know, Mr. Polidorus said, I'm done with that, I want a new will. But he never did anything. He never did. And you remember when I was questioning Mr. Pappas, I said, okay, this all sounds great. You were talking to him, which you really wasn't. And he wanted to do this because it came from him, which it really didn't, because it came from Lisa. So why all of a sudden, if you've been thinking about doing this for all these years, why all of a sudden is he doing it in the ICU, in the middle of the ICU? Remember, Mr. Cook told you this is about a hospital. It's gonna, it's like kind of like Pastor Hawkins was thinking. He was just in the general hospital. This is not that case. It's an ICU. It's an ICU which he'd been in for, I don't know, 2 or 3 weeks. He'd been in the hospital since January the 3rd. He'd been in the ICU for a couple of weeks, and he stayed in the ICU until, I think, early April. So what that means is, rather than, this is the story that they want you to believe. This is the George Polidorus that signed the will, or something like that. I mean, that's what he showed you in opening, George Polidorus, and that was a better time, a good time for George. But that's not the George Polydorus that signed that will. This is, I believe, February the 6th. So this is the picture, and this is all in evidence of the George Polydorus who signed the will. And he's got all the things and all the equipment around him that Mr. Donaldson did not remember. So what I'm trying to do is, as opposed to telling you what George wanted based on a document that Lisa and the lawyers who didn't really know what was going on with him did, I want to show you the true George Polydorus. You heard Monty say how robust he was and how robust he sounded. That's not what that picture shows. Let's talk just a little bit about some of the medical. I'm not going to bore you to death, but I mean, I'll bore you to death shortly, but briefly. But February the 1st, medical records, pages 1, 2, 6, 4, 8, altered level of consciousness, positive for inattention. I picked the first because that's when he was supposedly masterminding his will in this document, Exhibit 1C. Short-term memory loss, decreased recall of recent events, decreased short-term memory, impaired sequencing, cognitive impairment noted. February the 8th, acute respiratory failure with hypoxia, desaturates to 75%, confusion in nerve nodes, memory lapse, prednisone, low blood sugar, depression, and anxiety. And they talk about the pressure wound in the ears from his cannula, which again, I think it's kind of interesting that he's wearing that cannula so much that it's, I mean, it's not interesting, it's painful. I mean, it's a bad, and maybe he didn't fully appreciate it. He was on drugs, he was on Presidex, he was on things to try to keep him calm. Remember, Dr. Merkel said Presidex is to kind of make you compliant, and it's used to intubate people. It's something to sedate you. It's a sedative. February the 9th. I got page 10585, short-term memory loss, suffering from anxiety, hyperventilating, patient anxiety, sleeping between care, positive for confusion, desats to 89% at 11 a.m. with 28 respirations per minute. And then the 10th, 11th, and 12th, altered level of consciousness, agitation, confused. And what I would like to do is at this point on the 10th, if we could play the voicemail, and while Ms. Smith is doing that, here is a list. I've got a list of things that I tried to call out of the medical records. I'm not going to go through every one of them. But on the left side is medical conditions, kind of speaks for itself, treatment and medications. I'm not sure I got all of this, but maybe Ms. Smith, if she wants to, can fill it in when she gets a chance. Let me know when you're ready. I appreciate it. Okay. And let's go, while we're doing that, let me go through the court's chart. Oh, can't do that. Okay.
Dorothy did in quarter four. I just talked to Nikki for a while. Give me a call. I hope I'm not sleeping. Thank you.
And I'm not gonna put the whole thing on there, but there's about a 30-second lapse after that. And the last part of where he's talking at, he said, I hope I'm not asleep or I'm not sleeping. At first I thought he was calling her and said, I hope you're not asleep. But he said, I hope I'm not asleep. That's the delirium. That's George Polydorus talking to you on February the 10th. Now, they may say, well, you know what time it was? Well, Dr. Merkel said, yeah, you can know what time it is. You can engage in a superficial conversation. You've got a clock in front of you. You've got nurses trying to orient you all the time. So that's, to me, that speaks for itself. That is not the picture of the George Polidorus that they're trying to paint. Now, let's go to the questions. Again, Dr. Merkel went down the elements about testamentary capacity. It's question number 1. And I'm not going to belabor this, but you make your own decision. I think Dr. Merkel stated that there was a definite no on 2 of them. The first, did he have sufficient mental ability to understand the general nature and extent of his property? He said no to number 3. He said maybe. And number 4 said has sufficient mental ability to he said, yeah, maybe he knew his next of kin. And then on number 5 had sufficient memory to collect all this in his mind, all the elements of his business to be transacted long enough to perceive the obvious relation. Well, anyway, you see the rest of it. He said no on number 5. So no on 3 and no on 5. I think that's what the evidence clearly shows. And then for question number 2, does the document meet all the requirements? And I think the problem is not the credible witnesses. They were fine people. They just didn't know. They were kept in the dark. They didn't know about his medical condition. It was against protocol. You heard, well, it's not proven that it was against protocol, but you heard Dr. Merkel say, no, you really shouldn't be doing this if you don't have somebody medical involved to explain the medicines and the mental condition. That was not done. Maybe that's why Pastor Hawkins felt like he was going out on a limb. Maybe he was a little bit confused and conflicted as well. And also consistent with the answer to number 1, there was no intent because he didn't have the capacity. I think that's the answer. So the answer to that one should also be no. And then question number 2. Oh, I'm sorry. I was looking at the wrong one. That's the, yeah, I jumped ahead. This is number 2. Yeah, question number 2. Did I discuss that? Okay, good. I'm losing my mind. All right, question number 3 is, do you find that a relationship of trust and confidence existed? I think the answer is yes, husband and wife, plus under these circumstances where he's so sick and so dependent on her, she was controlling things in a way, and he was relying on her. And then answer to question 3B, undue influence. Do you find that the document was not the result of undue influence? Now, this is a double negative, but I think the evidence shows that he was unduly influenced by Lisa, so that answer should be no to question 3B. And then question 4 basically asks the same thing, except it's not a double negative. Depends on the burden of proof. The answer should be yes. Question number 5, did George have just cause? Yes, he had no choice. He didn't want to do this, but if your dad, even if you're haven't seen your dad, you're not especially close, maybe you're too much alike, you still love him, and if you feel like somebody's taking advantage of him, you're gonna protect him, aren't you? I would think. Did he bring this in good faith? For the same reasons. I think he felt like he had no choice. As far as the attorney's fees, I testified about that number and how that's a lot of money. I understand that. It's up to you whether you want to award it, but we spent the time. We used our best to try to get look, it seems maybe simpler now as to what the issues are after you've gone through all that stuff. But when you get into something like this, when you're facing that kind of opposition, it's all very confusing. It's kind of like a fog of war. It's chaotic. And you had to filter through all that stuff to try to figure it out. Now it seems simple. At the time, it took a lot of work and time to do it. Representation to the Court of Appeals. I told you about my appellate lawyer to the Supreme Court of Texas, merits briefing, and oral argument also. The next question, number 11, did Lisa act with good faith and just cause? She did not, and I'm about to get into why I think that's the case. And by the way, we've heard testimony, Mr. Cook elicited, in people arguing about what's in the estate. What's this worth? What's this asset? What's in this account? If the lawyers in here are fighting over it, can't agree with it, how could Mr. Polidorus have known how to deal with that on February the 9th in the hospital? This was a complex, certainly too complex for someone like Mr. Polidorus in the condition that he was in to deal with on February the 9th. Maybe some of you are, how much time do I have? Getting close, right? Okay, some of you may be thinking, well, this isn't fair. It's 3 of them versus her. That's not right. Well, first of all, they're siblings. They didn't choose their number, and that's what they had to do. They didn't want to do this. I think the evidence shows that Lisa was holding all the cards. She knew all the evidence. And if any of you back there say, look, all these people, they got too much money, too much time on their hands, a pox on all their houses. I understand that. Why am I spending 8 days or 10 days on this with these rich people fighting over stuff? I understand that. But what are you going to do? What are you going to do if your dad's been taken advantage of and nobody will right it? We mediated this case twice. Nobody will right this situation. So, go ahead, sorry. So, what are you going to do? He had no choice. He had to bite the bullet and do this, even though he didn't want to. And what I would like to do is show you one last document. It's RLP 00465, and it's a text string. And it's between Lisa and Mary Hart on February the 8th. Afternoon, I believe it's the afternoon, evening before the will signing. By the way, Dr. Hart met with Mr. Polidorus and never mentioned the will signing, which apparently just happened. It's kind of odd. If Dr. Attar was really in detail going over Mr. Polidorus and his day and what he'd been doing and how he was doing, no, he was just doing there checking out his part. That's all he was doing. All right. Page 465. All is well. This is Lisa. All is well now. The attorney got the stuff he needs. He's going to see George in the morning to sign. I will see George in the afternoon. If you're feeling sorry for Mary that she's being outnumbered and picked on, I recommend you read this text on the 8th at 7:10 p.m. Thank you, Mary. You are my angel. Mary's the girl Friday who was taking care of the business to a large extent, Mr. Polidorus. She's the one that got the loan forgiven by the will at the time that Lisa was providing information to the lawyers. Thank you, Mary. You are my angel. I'm so terrified. I don't know why. I'm just so scared. If George is doing so great in February, why is she scared and terrified? I feel like it's gonna, oh, here it is. You're worried about them ganging up on her. She's gonna massacre them. I feel like it's gonna be the Polidorus chainsaw on massacre. You heard her explanation. You can take that. I don't see how you get around that. I don't see how you get around the fact that these children of George Polidorus are going to be massacred as a result of what she had just done with Dan Pappas and the information she sent him when he was in the condition that he was in on February the 9th. What else can that mean? Oh, I get it. Sometimes I get angry and I say things I shouldn't say. Well, we all do that. But we don't plot and scheme and try to massacre our stepchildren with a will like she did on February the 8th, 2022, with a conversation with Mary Hart. I really do appreciate your time. I know this is an imposition, but you are doing democracy here. This is very important. And I would like to thank you on behalf of all of us.
Thank you, Mr. Bedford. I know that you were, Ms. Smith, keeping time at a strict 30 minutes, but I just want to reiterate that I wasn't holding you to a strict time. I imagine that Mr. Cook is going to want some kind of rebuttal, and so I was really figuring 37 to 40 minutes each over here. But again, take your time and put on your case, okay?
I will do my best to be efficient.
I thank you. I appreciate that.
Thank you again for being here. There has been a lot of discussion in this case about the 2022 vote. We've heard over and over about the timeline from February 1st of 2022 to February 9th of 2022, and then some days after that. Ultimately, this isn't really about a will. This is about a man named George Polidorus. Although the witnesses might disagree about the circumstances surrounding the will, about what may have happened during that time period, they all agree on one thing. George Polidorus was strong. He was smart, analytical, opinionated, a tough negotiator, careful and thoughtful about business and financial decisions, someone who drew a hard line in the sand when it came to his businesses and making decisions for his family. And that's really why we're here today. We're here in this courtroom at the end of this trial because that same man that I just described executed a will in the ICU. On that day, he was suffering from oxygen deprivation, cognitive issues. He was on a cocktail of drugs that were tranquilizers as well as drugs that induced mood swings and judgment impairment. And at that same time, he signed a document that he could not have possibly understood at the urging of someone he should have been able to trust, Lisa. We're asking for your help today. You heard at the beginning of this case and today that Lisa has the burden of proof to show you and prove to you that George had testamentary capacity at the time he executed that will. That means she has to show that it is more likely than not, greater than a 50% chance, that he had that capacity on February 9th of 2022. She's failed to meet that burden. And we'll talk about the burden on undue influence in just a moment. But I'd like to go through some of the questions that you're going to see on this jury charge. Before we do, I want to address one issue that's come up in this case that is not going to be in this document that you see here before you. And that's that document that was signed allegedly in 2015. We've heard a lot about it. Mr. Cook stated today, it's not a valid will. It's missing 2 pages. It's not being offered for probate. And you've heard that George's lawyers knew that from 2015 to 2022, there was a lot of discussion about his estate plan, what he wanted to do. He changed his mind constantly. And so when we're talking about this document in 2015, that is not in your questions today. The focus today is whether the 2022 will is a valid testamentary document. Let's go to the first question. Did George Polidorus Sr. have the testamentary capacity to sign the document dated February 9th of 2022? There are 5 elements and we'll go through them. Elements 1, 2, and 4 talk about some things that Dr. Merkel said he might have been able to do this. That he has sufficient mental ability to understand he's making a will. Said maybe, possibly. Sufficient mental ability to know his kin and natural objects of his bounty and their claims on them. Means he knows who his family are, who might inherit his estate. Dr. Merkel said possibly. Dr. Merkel also said that he might have been able to understand the effect of making a will, that he knew he was signing something that might have been a will. The problem is, and if we can move on to the next slide, thank you, Jessica. The problem are elements 3 and 5. Element 3 is George had sufficient mental ability to understand the general nature and extent of his property. And this might also pertain to the effect of making a will. That one is for you, Jessica. Element 5 is George has sufficient memory to collect in his mind the elements of the business to be transacted, to be able to hold the elements long enough to perceive their obvious relation to each other and form a reasonable judgment as to these elements. That's a lot of things that George Polidorus had to do when he signed that will. And so taking into consideration these three particular elements and remembering you have to find that he had the ability to do all five of these things. It's not one or the other. To find that he had testamentary capacity, he had to be able to do all five. Talk about evidence of lack of testamentary capacity. This is a timeline we have put together with the page numbers from the medical records. And you'll see for each date on the relevant time period, particularly in February of 2022 over here, we have short-term memory loss, poor safety awareness, and it goes on and on and on every single day in this relevant time period. And I included for reference some in January when Lisa Polidorus talked about the fact that he was ill in January, but then improved in January. Improved in February. The medical records simply do not support that. These entries are consistent for almost every single day from January to February 2022. Dr. Ali was here and he testified, and the takeaway that I got from his testimony was that he might have changed his opinion if he'd had more information. He got the medical records, but he didn't review flow sheets, he didn't review the nursing notes, he didn't review the lab results, didn't take those things into account, didn't look at the neuro interventions notes. All of those things are the active confusion assessments, the neurological assessments that are happening on a day-to-day basis. The doctors who are doing their rounding are not doing those assessments. So when Dr. Ali is testifying and telling you that the progress notes don't show cognitive impairment, the doctors aren't doing those assessments at that time when they're appearing. Lisa is telling you that George somehow regained full capacity at the time that he signed the will and was able to understand all five of those elements just fine. The first problem with this theory is that Lisa wasn't there, and the medical records don't support that fact. There's no evidence that George somehow had a regain of full cognitive ability. The medical records actually show the opposite. They show that he desaturated around the time of the will signing to 89%. And they show confusion on the date of the will, the date the will was signed. You've also heard Dr. Merkel tell you that George was on a delirium protocol consistently through this entire time period. He was not taken off of it during this time period. That means he has some level of delirium during the time that the will was signed. Lisa also admitted that George didn't have capacity in the first few days of February. Lisa specifically texted Christy and Dorothea about his agitation and his confusion on February 2nd, which was 1 week before the will was signed. And interestingly, Lisa's own text message is consistent with the medical records on that date because there's an entry on February 2nd where the doctors say that he is so agitated and anxious about the fact that his attorneys are preparing this will, he's not able to sleep. Lisa herself confirms the accuracy of the medical records and George's cognitive state at that time. Monty Donaldson testified the will was executed around 11 a.m. But Monty Donaldson didn't remember that George was wearing this large cannula, that he was wearing headphones, a microphone. He didn't remember George being breathless, which was shocking considering his condition and the testimony of other witnesses. He also said that George wanted to talk politics, was using colorful language, things that, as Dr. Merkel said, there's no way he could have done it, particularly if he was in a sitting position. In fact, he had to have 2 people get him to sit up. He could not do that on his own. And if he was sitting up, his oxygen desaturated significantly. The medical records, Lisa's own text messages, and Dr. Merkel's testimony confirmed that George would desaturate with any type of exertion. And that's the 89% level is important because that's the level, as Dr. Merkel told you, doctors really become concerned. That's when they start considering intubation. Of course, for COVID patients, that's not something they do, but that's the level of severity that we're talking about when we say oxygen deprivation. There's also testimony in the record that this level of oxygen deprivation causes cognitive deficits. Looking at elements 3 and 5, they have one thing in common. You've heard a lot of testimony about the complexity of this estate, the ability of someone to understand the businesses, the real property, the values, the amount of money that's in the accounts, the income that's producing from some of those properties. The will would have necessarily required George to contemplate all of these things at the same time and understand what he was giving to whom. He did not have the ability to understand the complex nature of his properties, his businesses, his accounts, and there are inconsistencies in the will that show that. The will contains unnatural dispositions that clearly demonstrate George did not know the nature and extent of his property. For example, Nikki's account of prosperity, the one ending in 6899, that's in exhibit 9, if you want to take a look at it, it had a beneficiary designation already when he signed the will. You don't put an account in a will that you've already put a beneficiary designation on. And regardless of the beneficiary designation, the 6899 account, according to Dan Pappas's records, was supposed to have $120,000 in it. Whoever told Dan Pappas that it was supposed to have $120,000 was completely wrong. Whether it was George or Lisa, that information was incorrect. For the Moody account that goes to Nikki in the will, that account can't pass to Nikki under a will because George didn't own it. The only thing that George was on that account was a representative payee. And you heard Christy testify yesterday, a representative payee just receives the funds and controls them, helps pay bills. They don't own that money. It's not something he can give away. The cemetery, so for the one person that George, multiple witnesses agreed, George wanted to make sure he took care of, which is Nikki, that he was concerned about his care. The gifts to Nikki are all wrong. On the cemetery plots, you heard testimony about the cemetery plots. There are 18 of them remaining. George was Greek Orthodox. He bought cemetery plots for his family. There was an expectation that other members of his family would be buried so that they would be all together as their religion describes. It makes no sense why George would give 18 cemetery plots, specifically in that residuary clause, to Lisa. The ambassador property, assuming the administrator is correct on her inventory, the ambassador property is shared ownership between George and Lisa. When he executed the will, George did not recognize he was only gifting his half of the property, Dorothy and Christy, and that they would share their property with Lisa. If George had known that and understood that, do you really think that he would have given a property where his daughters would be co-owners with his wife? The answer, if we can move one slide, the answer to whether or not George had testamentary capacity is no, he did not. Question number 2, does the document dated February 9, 2022 meet the following requirements? And they're listed there. The first 3, I don't think anybody disputes. It's in writing, it's signed, George was over the age of 18, etc. As to element number 5, as to whether George signed the document with the intent to dispose of the property, Mr. Christopher addressed this as well. If he doesn't have the capacity, he can't have the intent to dispose of property at his death. Number 4, though, I want to talk to you about the 4th element as to the credibility of the witnesses. And again, not disputing the fact that the witnesses are not, I don't think the witnesses are lying, and I'm not saying that they were, but the credibility requirement here is not whether or not they were just lying to you on the stand. The credibility is the actual credibility of what they're telling you about their recollection, about their experience with George at that time. Chuck Hawkins and Jessica Laster, for that reason, are not credible witnesses to the will. They both had to swear under oath, this is their self-proving affidavit, that they were at least 14 years of age, that George declared the document to be their will, that George requested them both to be witnesses, that George signed in their presence, that George was married under the age of 18, and most importantly, that George was of sound mind. Chuck testified that he had no doubt regarding the accuracy of the medical records, no reason to dispute them. But when he was asked about his observations of George at the time, he testified that George was not confused, was not agitated, was not anxious, and not just on the day of the will, on all of the occasions that he met with George before that. Chuck had met with George prior to the signing of the will on February 2nd, 4th, and 8th. Lisa actually sent those texts to Christy and Dorothea on February 2nd, saying that George was agitated and confused. Chuck didn't observe any of that. And then February 4th, Lisa texted Christy and Dorothea again, saying he was agitated. Chuck did not recall any of that when he met with George. What's also odd is that Chuck testified that he would go visit with George during the day. And so in these 4 encounters with George, the 2nd, the 4th, the 8th, and then when he witnessed the will on the 9th, he testified he never met Lisa. And Lisa said that she was there pretty much every single day throughout the day until she left in the afternoon. So that is an odd part of his testimony to me, and I don't know how he could have possibly not learned it. Jessica Laster's assessment of George as having sound mind is not credible either. And because she had no assessment of his sound mind at that time. She was in there for 5 minutes. She didn't know who George was before she entered the room. She certainly wasn't his favorite nurse. She did not speak to George while she was there. And if she doesn't do any of those things, if she doesn't even speak to him, there's no way for her to actually assess whether or not he has sound mind to execute the will. An interesting fact about this affidavit is that the affidavit also requires the testator, meaning George, to request the witnesses to be witnesses directly. It says that the testator asked them to be the witnesses to be present. Chuck testified that he was the one that went and got Jessica from her office to come witness the will, not George. So that particular fact fails to meet the requirements of this self-proving affidavit. From a credibility standpoint overall, Monty and Dan agreed that George's favorite nurse witnessed the will. We know that's not true because we know Jessica Lasser was unit secretary who had never met him before. And both Jessica and Chuck, as well as Monty Donaldson, all testified, every single person who was there at that will execution. Not one of them asked a doctor, a nurse, any medical provider whatsoever about what conditions George had, what medications he was on, and whether he was able to execute a will. There was simply no diligent inquiry whatsoever as to whether George had sound mind. And that is why the answer to number 2 should be no. Question number 3A. Do you find that a relationship of trust and confidence existed between George Sr. and Lisa Polidoro as spouses? And if we can move one more slide, there is an instruction about what this question requires. And it is more than just being a spouse. Nobody disputes that George and Lisa were married. But to find a confidential relationship, what we're saying is Lisa was more. She was something beyond just being spouses. That there was this trust, this confidential relationship that they had such that George relied on her to act in his best interests. Lisa testified herself that she helped run George's businesses. In fact, when she was initially referred to as the secretary, Mr. Cook elicited testimony that Lisa did more than just secretarial work. She was actually writing checks on at least one, if not more, of George's business accounts. There's testimony regarding Lisa's authority to write checks for George's company called P1 Investment Company. And you'll see the name of the company if you see corporate authorization resolution. P1 Investment Co. is right underneath that title. On this document, which is in Exhibit 9, as part of the bank records, George actually named Lisa here as an authorized signer. And these people are listed as agents, both of them. Meaning Lisa is an agent for P1 Investment Company. George named her in that role to act for the company. And the evidence is shown in Exhibit 9 that Lisa actually did write checks for P1 Investment Co. If we go to the next slide, there is a period, this is kind of hard to see this graph on what the colors mean. Blue is George and the orange color is Lisa. And so we see George kind of hit, he has a spike in maybe 2017, 2018, he writes some checks. He writes some more checks going on. In 2022, George's check writing is 0. Guess whose check writing is way up here? Lisa is actually writing more checks on this account in this time period than George ever did from 2016 to 2023. And so what we see from here is that Lisa was taking that agency, that appointment that he gave her in those records, and using it while George is in the hospital to write those checks. This is what we're talking about when we say spouse with something else. She's acting as an agent on this account. She's named in that capacity. And she's writing a bunch of checks while he is not able to do so. Also around the same time on January 24th, if you stay on the right of that slide, there's the text message where Lisa tells Christy and Dorothea that she and Mary are handling the business matters for George, so he doesn't have to worry about it. Dorothea testified even though she knew Lisa was signing checks, that she knew Lisa was signing checks for George because he was not able to do so. January 29th, another text where Lisa says, George doesn't want to hear about the businesses. That's why Lisa was doing it. And he relied on her to do it well. She took advantage of that relationship. So the answer to question 3A, were they in a relationship of trust and confidence beyond being spouses? Yes, they were. If you answer yes to confidential relationship, you move on to question 3B. If a confidential relationship exists between George and Lisa, that means it's presumed that there's undue influence of some kind, because there has to be fairness. And so what Lisa has to show, if you find a confidential relationship, she has to show you that there was not undue influence. That becomes her burden if you determine that there was a confidential relationship that existed. And I want to talk to you about the circumstances that lead to undue influence and why that undue influence was there when the will was executed. Lisa was at the hospital more than anyone. She was coordinating and arranging for family members to appear. And one more slide. Lisa called Dan Pappas' office on February 1st. At least once. There's another note from a phone call, we don't know who he was talking to. And then that same afternoon, she sends the now infamous email at 3:58 p.m. regarding the changes to the will. And I want you to consider this email very carefully. Because if we read it together, it says, attached are the things I wrote today for the will. This is Lisa. Let me know what you need from me. This is about Lisa. Nowhere in that email, anywhere, does it say anything about George. This is Lisa. These are the changes I wrote. Let me know what you need from me. Where is the reference to George? And then there are the handwritten changes, as we all know, attached to that email. Lisa claims George dictated them to her, but Lisa's the only person that can testify to this because apparently she's the only one that was there. George's medical condition also calls into question his ability to dictate because he couldn't breathe. We also know Lisa planned out in advance that when Christy was going to come see her father, and she made sure that Christy wouldn't be there until the 10th, one day after the will was signed. So she finds out on February 7th that Christy won't be there till the 10th. On the 8th, she sends more changes to Dan, which she admitted she didn't write from George's dictation again like she did on the 1st. She just typed them up from home and sent them to Dan. There's no testimony that George dictated those to her. And then the will's executed on the 9th. Christy doesn't end up coming, but she wasn't supposed to be there on the 9th anyways. Let's address Lisa's motivation to have this will executed. You've heard multiple witnesses testify that the value of the estate is $4.5 million. Lisa gets that the $4.5 million estate, the bulk of it goes to Lisa, and that the collection of the specific gifts that are in that will are maybe no more than $300,000. And as Dan Pappas testified, without the will, the estate would have been split differently, where everyone would get something. And Lisa has shown motive to take control of George's property and accounts, regardless of the will. We have a temporary administrator, Ms. Wiesenthal, and that testimony has shown Lisa would not turn over estate property to Ms. Wiesenthal. Lisa was running the businesses. She's paying herself $5,000 a month in management fees. Even now, Lisa is still running businesses and controlling all the accounts because she will not turn this over to the person authorized by this court to do so. Lisa also has no regard whatsoever for George's wishes on the prosperity account 4574. Christy and Nikki were named as beneficiaries. George and Lisa signed a document for the bank account to go to them as payable on death beneficiaries. And there's no evidence that Lisa ever contributed any funds to that account. When George died, Lisa went to the bank. She took off George and she took off Christy and Nikki, put her daughter on. There is no evidence at all in this case that George ever intended his money to go to Lisa's daughter, Haley. In fact, Lisa testified that George refused to pay anything for Haley when Haley was living with them when they first got married, and that Lisa had to work so that she could pay Haley's expenses. This is another example of how Lisa did not care what George wanted. And lastly, George's medical condition is clear evidence of his susceptibility to exploitation by Lisa. Lisa didn't need to be standing there when the will was signed, pen in hand, to make sure he signed it. She'd already done all of that work. She drafted the changes. She got all of the changes over to the lawyer, got the will finalized. And by the time that the will was signed, Lisa had already made sure that his kids wouldn't be around to to maybe run into some witnesses or see the will signing. He intentionally ignored George's weak and critical condition and cognitive state at the time, because to acknowledge it would be the undoing of this will. And I would also check, I think Mr. Christopher's already touched on this, but I would also point out, she knew exactly what she was doing at that time, on top of all the evidence I've already told you, because she told Mary Hart it was going to be a Polydora string-time massacre. She knew she was going to break this family up by getting that will signed. So going back to question 3B, it's a double negative. They hurt my brain. I hate them, but that's what it is. Do you find that the execution of the document dated February 9th of 2022 was not the result of undue influence? The answer is no. If for some reason that you don't find a confidential relationship, that's when you're going to answer this question. So there are 2 questions on undue influence. You will only answer 1. So if you find that there is no confidential relationship, you're asked, was this document dated February 9th of 2022 a product of undue influence? The answer is yes. All of the same reasons I've already reiterated. Questions 5, 6, and 7 pertaining to good faith and just cause for George Polidoros Jr. were addressed by Mr. Christopher. I will not go through those again with you, but if we skip to question 8, this pertains to my clients. Did Dorothea and Christy have just cause to bring this lawsuit? Absolutely. Initially, when they were talking to their brother and George was getting their thoughts about what they experienced within the hospital, this is a fact-finding issue. Christy and Dorothea didn't hire lawyers. They certainly didn't hire Crane Hayden. They didn't retain any counsel at that time. They are a cohesive family, as you heard them testify, but they're supportive of their brother. And so, yes, if he had questions, they answered them. And they did not enter a contest at that time either. In fact, the will contest was filed in April of 2023. They didn't join until the following January. And by that point, they had an opportunity to really look at the case for themselves, review the records that had been produced, and learn more facts about the case before they joined in. They didn't make that decision lightly because they wanted to make sure it was the right decision. I'd like to talk to you about what reasonable grounds and fair and honest cause or reason means. The evidence provided to you in this case speaks for itself and shows clear justification for Christy and Dorothea joining their brother in his contest. The medical evidence clearly shows that George was in a terrible condition at the time he signed the will. Cognitive deficits are noted throughout his record on every single day around the signing of the will. Take those records and combine them with Lisa's fingerprints all over Dan Pappas' records, and there is no question that Christy and Dorothea were justified in filing their will contest. The answer to just cause for Christy and Dorothea is yes. The next question pertains to good faith, prompted by an honesty of intention of reasonable belief that the action was probably correct. This is similar to just cause. Again, they filed and maintained their lawsuit in good faith. You've heard the evidence. There's at least a question, at minimum, a question of whether George had capacity at the time he signed that will. And the evidence, as it was produced in this case, further gave them reason to maintain their lawsuit and the contest of this will. They were more than justified in bringing and maintaining this will contest. The answer to question 9 is yes. Moving on to question 10. What sum of money do you find for Christy and Dorothea's attorney's fees? This was the drudgery that we went over yesterday afternoon. For representation in the trial court, the reasonable and necessary attorney's fees that Christy and Dorothea have incurred are $173,230.80. If this case is appealed, we have requested $15,000 for representation in the Court of Appeals, $10,000 in the petition for review stage in the Supreme Court, $10,000 in the merits briefing stage in the Supreme Court, and for representation, if oral argument is requested, sometimes it isn't, sometimes it is not. In the Supreme Court, the answer for that one is $5,000. Lastly, question 11. Did Lisa Polidoros act in good faith and with just cause in prosecuting this suit for the purpose of having the will admitted to probate? First of all, no. What evidence did Lisa show you that she filed this document for probate in good faith and with just cause? What evidence? She was at the hospital more than anyone. She knew George's condition. And when I asked her about the condition that George was in, and as it was stated in the medical records, are you aware that he suffered from this cognitive deficit on February 1st? No. Do you want to see the records to confirm? No. Every single day she said no. That's because she knew what was in there. She's texting Christy and Dorothea what his cognitive state is in that time. George was agitated and confused the first week of February, leading up to the signing of the will, consistently, every single day. Lisa disregarded those notations and her own experiences because it didn't fit her narrative. She knew what those records said. This was a concerted effort by Lisa to get a will signed by taking advantage of the circumstances. A will that George had contemplated, with his estate planning lawyers had changed his mind. Estate planning thoughts and discussions that he had over years but never fully finalized. When he was well and when he was healthy, he never signed anything. But then all of a sudden, he's in the hospital. And he's signing this document that benefits her. Lisa took this opportunity while George was in a severely weakened state in the hospital to ensure that he signed a will that benefited her. The answer to this question, did Lisa Polidoros act in good faith and with just cause? When she filed the document dated February 9th of 2022 for probate, the answer is no. As to question 12, there's a conditioning at the very top. We can move one more slide. Or do we have one more slide? I didn't make a slide for this one because you're not going to answer it. If you find that she acted in good faith and just cause, at that point, you would answer for her attorney's fees. But if you answer no to this question, as I just asked you to do, you will not answer question 12. I want you to remember, Lisa saw what she wanted to see. She ignored what was actually going on with George. Even in the text messages where Lisa says, oh, George is having a great day, the medical records simply don't support that. The fact is that George had a great day when Lisa needed him to have a great day. In reality, George was suffering from hypoxia, confusion, altered mental status, all of which reduced him from the strong, opinionated man that he was to a vulnerable, ill person, susceptible to exploitation and wholly reliant on his wife. Again, he had years to execute a will when he was well and healthy and competent. But he didn't do it because he couldn't make up his mind. His will was not executed when George had the capacity to understand the complexities of his estate, and it was the product of Lisa's undue influence. I am asking you today to find that the will is invalid for these reasons. Thank you.
Thank you, Ms. Smith. Mr. Cook, before we go into rebuttal, I think we need to take a little bit of a break. Our court reporter's been at it for a couple of hours and she's very, she needs to rest her fingers for a minute, okay? So let's take about a 15-minute break and then we'll come back. There's going to be a rebuttal. And after that, the case will be submitted to you, okay? All right.
All right, for the hearing.
I do want to address the polygamy on that. Lisa would apologize for that. And what she told you was, when her husband got pissed at the kids, it was the polygamy chainsaw massacre. And if you look at those texts, the kids are constantly pushing medications, different forms of treatment. George is in the hospital trying to take care of himself and getting pissed. That's what that reference is to. They said George didn't want to file this lawsuit. Y'all know why George didn't file this lawsuit, because he's mad. He's been mad for 33 years. He's mad. For whatever reason, he didn't make up with his dad. His dad tried to reach out. He wrote a really sweet letter. You guys saw that. It was a nice letter. He wrote this letter back, and it was just mean. He's still mad. He's still angry. That's why he filed a lawsuit. Not because he felt like he had to. The medical records, the exhibits, you see me every now and then go reaching over and taking pictures of the medical records. There's an exhibit they showed, it was blue. I wish you could have seen it. You could always ask for it. But what they did was, they must have spent, 2 weeks, 4 paralegals, 6 attorneys, working on this, going through all the medical records to come up with this is the list. This is it. And I told you, they'll give you the dates, but they won't give you the time. There are no time stamps on it. The other thing, you can't see, I wish you could blow it up bigger, but there's only one reference on February the 8th. Only one related to confusion for all these states. One. After spending hours, I'm sure, combing the records, trying to find every little bit of evidence they could. That was it. They go on the screen really fast, they look at all these here, and take it off. And ask for it. Here's the other thing too. A lot of this is show. Did anybody once see anybody go over here and open up any of these boxes? I think at one point somebody was hammering the boxes like that. If you got good facts, you hammer on the facts. If you don't have good facts, you hammer on the table or the boxes. This is a show. It's a prop. This is real life. We're trying to present the evidence. We're trying to show, hey, here's who came in. These are the people who saw him. Yeah, these are the medical records. We're not hiding anything. We tell you if there's bad facts and there's good facts. But what happens is the issue is, was he to have testimony capacity at the time he signed it? That is the question. Here's the other thing too. They hate that 2015 bill. Because they can't answer this. They cannot answer. Why would this be Lisa's will? They keep saying this is Lisa's will. Lisa did it. She took advantage of her husband, who she loved and cared for. And yeah, she was up there all the time. And they want to punish her for it and say, oh, she's got a confidential relationship. Look at the checks that she was writing after he came home. That's what they're complaining about. Look at the checks. They can't look here, they look fancy. Look at the checks she's writing. It's out of a P1 account. There is no business with P1. She's writing personal checks. And she's writing checks for George's church, which she joined when she got married. She's writing for his medical care. That's what she's doing. It's not business. She's just helping her husband. They can't come up with an answer to this. Why wouldn't Lisa want this? Why would Lisa want this? If this is Lisa's will, that's what she wants. It's more money. This is what George wanted. And yes, he left her the lion's share of his estate. That's what he wanted to do. That was his wife. Cemetery plots. Again, we're still in the cemetery plots because she's not blood. No. When they got married, they're one. They're beyond blood. Why did he give her the cemetery plots? Do you think any of them would allow her to be buried next to her husband if they own the plots? No. And also, she's not gonna sell them. Kathleen Wiesenthal. Last thing I want to talk about. They keep talking about Kathleen Wiesenthal. This is the whole show you this, show you that. Kathleen Wiesenthal is a temporary administrator of the estate. She has the authority to manage the estate. She has the authority to take the businesses and manage the businesses if she wants to. She asked Lisa to continue doing what she's been doing, manage the properties. She owns part of the property. She's part owner of the property. And they want to say there's something deceptive about it. There's nothing deceptive about it. She's managing it with the authority of the temporary administrator. It just continues. Y'all, just think about the facts. Use your common sense. Either you're in camp one who believe that she somehow orchestrated everybody, to come in and testify about something that wasn't accurate. Or George wanted to change his will, he called his attorneys, he talked to them about it, and that's what he did. Last thing I want to do is, that picture of George Polydorus are pictures that, that's a picture that Lisa wanted me to show, because it's one of her favorite pictures of her husband. But as far as George Polydorus signed the will, it's this guy. I mean, he is sitting up in his bed. He is not gasping for air. Look at those eyes. I mean, super bright eyes. This is not the picture that Dr. Merkel painted for you guys. Look, he's sitting up, he's eating, it's probably, I think it's his birthday. Valentine's Day. He's eating a Valentine's Day cupcake. This is not the picture that Dr. Merkel painted for you. This isn't the picture that the daughters painted for you. When you go back and look at the text, never once did they say, "Oh my gosh, Dad looks so sick." They never said he's so confused. Not once. First time, you're in trial. There he is again. He couldn't eat. He couldn't sit up. He's sitting up right here in his bed. I don't see the two people assist. He probably just pressed the button to sit up. He's eating breakfast. This is the George Polydorus who signed the will. Not the George Polydorus who Dr. Merkel tried to paint the picture of. Just use your common sense. Honor the relationship. Honor George's wishes. That's all we're asking you to do.
Thank you, Mr. Cook. Okay, members of the jury, at this point, all of the evidence is now before you. The charge of the court is before you, and you've heard all the closing arguments. And so now you're going to retire back to the jury room to begin your deliberations. The bailiff will give you the jury charge with all those questions on it so you can review them. You'll need to pick a presiding juror. I don't know if you've done it yet or not, but you don't have to tell me. I'll ask you later. If any one of you has to leave the jury room for any reason, the deliberations must stop. Only deliberate while all 12 of you are in the jury room at the same time, okay? If you have questions, you're allowed to handwrite a note to the judge, and I will bring everybody in here. We'll review the question, and I'll try to give you an answer, but I'm going to give you something in advance of that. I cannot comment on the weight of the evidence or the credibility of the evidence. All I can do is maybe clarify something for you if you need a clarification, but most of the time I'm probably going to tell you, rely on your own recollection of the trial. And it's going to be a cryptic answer, and you're probably not going to like it very much. So be careful about, asking me. I don't want you not to ask me a question if one does come up. But if I give you an answer that's cryptic like that, that's the reason why I'm not allowed to give you any other kind of an answer. Okay. All right. And so now the case is before you. You can begin your deliberations as soon as you're all 12 in the jury room.
All rise for the jury.
Okay. Does the bailiff have your cell phone numbers? If you want to leave, go do something else, you can give her your cell phone number. You may want to get out of the building and go have lunch somewhere. Treebeards is a wonderful place. There's the Barnaby's right down there. There, it's all walking distance. There's a Thai restaurant over here, all within 5 minutes. But if you want to give the bailiff your cell phone number when she comes back out, she'll let everybody know in a group text when we have a verdict or when we have a jury question, because I'm not allowed to answer jury questions unless you're all here and it's on the record. Okay. Any questions?
I think so.
No?
Yeah, oh, maybe we use the courtroom for.
Yes,
Okay.
absolutely. You're welcome to stay here and that's perfectly fine. Yes, sir.
And I don't know, maybe you mentioned it, and I'm sorry, I was doing something else, but where are they gonna eat lunch? Are they eating downstairs?
No, we're bringing them pizza.
Okay, good.
And so they're having a little pizza party there after all the carbs they had for breakfast. Yes, I'm jealous.
Does she want to have them?
Oh, right. So we probably, yes, we do need to do that. Get something on the record here about the exhibits that are going to go back to the jury and that you've agreed to them and that you've also agreed to what has been admitted actually has been admitted. So if y'all want to just gather around the court report. And do this. Yes, get the
Progress on.
good. Because
I think, yeah, we got it. I'm not taking any credit for that. You're not the judge. Hopefully.
all right. Well, they'll probably be eating while we're doing this, so it'll be fine. Almost done? Okay. Sure. Yeah. Mhm.
All right, for the jury.
May be seated. Well, good afternoon. Has the jury reached a verdict?
Yes.
Yeah, I assume you're the presiding juror. Okay. Would you please hand the verdict to the bailiff to give to me? Thank you. Thanks very much. The verdict appears to be in proper order, and so I'm going to read the verdict to you now. And question number one, did George Nick Papadopoulos, or sorry, Polydoros, excuse me, did George Nick Polydoros Sr. have testamentary capacity to sign the document dated February 9th, 2022? Answer, yes. Question two, does the document dated February 9th, 2022 meet all of the following requirements? That it is in writing, signed by George Nick Polydoros Sr. in person, and when the document was signed, George Nick Polydoros Sr. was 18 years of age or older, or was married or had been married, or was a member of the United States Armed Forces, an auxiliary of the United States Armed Forces, or the United States Maritime Service, and the document was attested to by two or more credible persons who were at least 14 years of age and who signed their names to the document in their own handwriting in George Nick Polydoros Sr.'s presence, and George Nick Polydoros Sr. signed the document with the intent to dispose of his property after his death. Answer is yes. Question number 3A, do you find that a relationship of trust and confidence existed between George Nick Polydoros Sr. and Lisa Polydoros as spouses? Answer, yes. Question 3B, do you find that the execution of the document dated February 9th, 2022 by George Nick Polydoros Sr. was not the result of undue influence? Answer is yes. Question number 4 is not answered, which is correct. Based on the precedent, the preceding question. Question number 5, did George Nick Polydoros Jr. have just cause to bring this lawsuit? Answer, yes. Question number 6, did George Nick Polydoros Jr. bring and maintain the lawsuit in good faith? The answer is yes. Question number 7, what sum of money do you find to be necessary expenses and disbursements, including reasonable fees, for George Nick Polydoros Jr. to prosecute this suit to contest the validity of the document dated February 9th, 2022? For representation in the trial court, $355,495.93. For representation in the Court of Appeals, $30,000. For representation at the petition for review stage in the Supreme Court of Texas, $20,000. For representation at the merits briefing stage in the Supreme Court of Texas, $20,000. For representation through oral argument and completion of the proceedings in the Supreme Court of Texas, $25,000. Question number 8, did Dorothea Polydoros and Christy Stovall have just cause to bring this lawsuit? Answer, yes. Did Dorothea Polydoros and Christy Stovall bring and maintain the lawsuit in good faith? Answer is yes. Question number 10, what sum of money do you find to be necessary expenses and disbursements, including reasonable fees for Dorothea Polydoros and Christy Stovall to prosecute this suit to contest the validity of the document dated February 9th, 2022 for representation in the trial court, $173,230.80. For representation in the Court of Appeals, $15,000. For representation at the petition for review stage in the Supreme Court of Texas, $10,000. For representation at the merits briefing stage in the Supreme Court of Texas, $10,000. For representation through oral argument and completion of the proceedings in the Supreme Court of Texas, $5,000. Question number 11. Did Lisa Polydoros act in good faith and with just cause, whether or not successful in prosecuting the suit for the purpose of having the document dated February 9th, 2022 admitted to probate? Answer is yes. Question number 12. What sum of money do you find to be necessary expenses and disbursements, including reasonable fees, for Lisa Polydoros to prosecute for the purpose of having the document dated February 9th, 2022 admitted to probate? For representation in the trial court, $208,000. For representation in the Court of Appeals, $30,000. For representation at the petition for review stage in the Supreme Court of Texas, $10,000. For representation at the merits briefing stage in the Supreme Court of Texas, $10,000. For representation through oral argument and completion of the proceedings in the Supreme Court of Texas, $10,000. The verdict was signed by 10 of the 12 jurors, and each of the 10 have agreed that each and every answer has been answered by them and signed the certificate below. Jurors, is this your verdict? This is your verdict. All right, anyone like to poll the jury or?
No, but if we have an opportunity to talk to them, that would be very happy.
We'll talk about that in a second. No polling?
No.
Okay, all right. So ladies and gentlemen of the jury, thank you very much for the time that you've given us. This was an important case. This is an important verdict, and we appreciate you. At this time, you are released from jury duty, which means that you can speak about this case to whomever you wish. You may also choose not to speak about this case. That is your prerogative alone. The attorneys may wish to speak with you, and you may speak with them freely at this time if you wish. If you choose not to speak to the attorneys, that is your prerogative as well. You may just simply walk on home. Do you have any questions? Thank you very much for your service. Really do appreciate it. And bailiff will show you how to get out and gather your things and back through the hallway that you're very familiar with. Thank you very much.
All rise for the jury.